Court officer, am I audible? Court officer.
ಹಲೋ, ಆಡಿಬಲ್ ಇದ್ದೀರಾ ಮೇಡಮ್?
ಮತ್ತೆ ಯಾಕೆ ಇದು ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗ್ತಾ?
ಅದೇನೆ ಅವ್ರಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಇಟ್ಕೊಂಡು ನಮ್ಗೆ ಯಾಕೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗತ್ತೆ ಅಂತ ಪ್ರಶ್ನೆ ಕೇಳೋದು ನಾನೇನು. ನಿಮ್ದೇ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಇಲ್ಲಿ ಆಫೀಸ್ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಮೇಡಮ್. ಒಂದು ಚೂರು ಪ್ರಾಬ್ಲಮ್ ಎಂಪ್ಲಾಯ್ ಹೌದಾ, ಮೈನ್ ಸೆಂಟ್ರಾ? ಅದಕ್ಕೆ ಎಲ್ಲ ವಿಸಿ ತೆಗೆದು ಮುಂಚೆ ಚೆಕ್ ಮಾಡ್ತೀವಿ ಎಲ್ಲ ಫೋಟೋ ತೋರಿಸ್ತೀವಿ. ಹಲೋ ಪಲ್ಲವಿ, ಅದೇನೋ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಕನೆಕ್ಟ್ ಆಗಕ್ಕೆ ಆಯ್ತಿಲ್ವಂತೆ ನೋಡವ. 18 ಅಂತೆ ಎಲ್ಲ ಕನೆಕ್ಟ್ ಮಾಡ್ತಿದ್ದಂಗೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗ್ಬಿಡ್ತಾರಂತೆ, ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಂತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನೋಡ್ಕೊಳ್ಳಿ. ಹಲೋ ಅಂಜಲಿ ಅವರೇ, ಅಲ್ಲ ಇವ್ರೆ ಒಂದ್ 10 ಸತಿ ಫೋನ್ ಮಾಡಿದ್ದೀನಿ ನಿಮ್ ನಂಬರ್ಗೆ. ಫೋನ್ ರಿಸೀವ್ ಮಾಡ್ತಿಲ್ಲ ಯಾರು. ಅದ್ಯಾರೋ ಅಡ್ವೊಕೇಟು, ಅದೇನೋ ಡೇಟ್ ಇದೆ ಮೇಡಮ್, ಅದೇನೋ ಆನ್ಸರ್ ಡೇಟ್ ಬರ್ತಾ ಇದೆ, ಫೈಲ್ ಹೋಗಿಲ್ಲ ಅಂತ ಬಂದಿತ್ತು. ಚೇಂಬರ್ಗೆ ಹೋಗಿ ಅಂದ್ರೆ ಚೇಂಬರಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಮೇಡಮ್ ಅಂತ ಬಂದರು. ಒಂದ್ 10 ಸತಿ ಫೋನ್ ಮಾಡಿದ್ದೀನಿ, ಫೋನೇ ತೆಗ್ದಿಲ್ವಲ್ರಿ ಯಾರು. ಫೋನ್ ನೋಡಿ ಏನು ರಿಪೇರಿ ಇದೆ, ರಿಪೇರಿ ಮಾಡಿಸ್ತೀವಿ. ವೀಕಲ್ಲಿ ಮೆಮೊ ಮಿಸ್ ಆಗಿರೋವು ಅದೇಂತ ಕೇಳ್ಕೊಂಡು ಬರೋ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕಂತೆ ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಂತ ಹೇಳಿ. ಮತ್ತೆ ಮಳೆ ಇಲ್ಲ ಇನ್ನು ಅದೆಷ್ಟನೇ ತಾರೀಕು ಕೊಡ್ತೀನಿ
Yes.
Page wise adjournments. Page
Out of the list mentions.
Page wise adjournment.
I have filed a memo application for bringing LRs of the deceased. Hence, I am posting now.
Someday. Yes.
Page wise adjournment. List 1. Page number 2. Serial number 5 to 8. Page number 3. 9 to 11. Page number 4. 12 13. Page number 5. 14 to 16. Page number 17 to 22. Page number 7. 23 to 25. Page number 8. 26 to 28. Page number 9. 29 to 31. Page number 10. 32 to 38.
34. It is submitted the counsel for the petition is unwell. This is matter on 22nd of September.
Page number 11. Serial number 39 to 46.
Serial number 39, my lords.
Yes.
Serial number 39. I'm not keeping well, my lords. Short adjournment, my lords. For this Saturday.
Inform the other side.
Other side is not appearing. Notice to respondent has been held sufficient, my lords.
At the request of land counsel, the petition is this matter on Saturday.
Gratefully,
Serial
your
number
lordships.
46, my lord. In the first matter, my lord, I am appearing for the appellant. In the connected manner for the respondent, my lord. I place 1 week time, my lord.
Inform the other
Yes,
side.
yes.
At request, this is the matter on 24th of September.
43, my lord.
40?
Serial number 43.
Uh,
For the petitioners, arguing counsel has undergone surgery, my lord.
Inform the other side.
Informed, my lord. Informed.
At the request of land counsel, the petitioner, this is the matter on 19th of September.
Interim order, my lord.
Look at it wherever interim order. India.
Page number 12. Serial number 47 to 51.
It is submitted, the matter may be referred to the local adalat. Yes.
Page number 13. Serial number 12 to 54.
Serial number 52, my lord. In the first matter, my lord, I appellant, my lord. In the connected matter, my lord, I am respondent. I informed the other side counsel also, my lord. Is inconvenience, my lord, today, tomorrow, or my lord, next week.
If once it is adjourned, it will not come for the next 1 month. This is the matter on 23rd of September. At the request of land counsel, the appellant.
Praise.
Yes.
Number 14. Serial number 55 to 59. Page number 15. Serial number 60 61. List number 2. Page number 2. Serial number 4 to 6.
My lord, serial number 6, my lord. Well, actually, I am out of station. I am in native. I have to attend my mother's annual death ceremony. So, my lord, day after tomorrow. My lord. I am ready day after tomorrow. I filed an IA, moved an IA for early hearing.
We'll admit the appeal.
Well, it may be disposed of because only quantum. I filed an
It
IA.
can't come tomorrow. There are so many other matters. It's the matter.
Day after tomorrow. Day after tomorrow, if
16th of
possible.
September.
My lord.
Page number
16th of September.
16 9, sir. Serial number 4. Page number 3. Serial number 7 to 10. Page number 4. 11 to 15. Page number 5. Serial number 16 to 19. Page number 6. Serial number 20 to 25.
My lord, serial number 20, my lord. Sorry for the inconvenience, my lord. Any
Yes, this is also on the same day. At the request of land counsel for the appellant.
Date, please. I represent the first respondent. Date.
16 9, sir.
Acha.
Yes.
Page number 1. List number 1, parted matter, serial number 1, VB Sidramaya.
Wait for the respondent in this case, my lord. On the last date of hearing, my lord, the submission made by the petitioner is that, my lord,
By the time the counsel for the respondent shall get specific instruction about an amount of rupees 30 lakh that is transferred by the husband to the wife.
please, my lord. In this regard, my lord, in the petition itself stated in the said fact, my lord, in order to prosecute the respondent number 2, he is now studying in MBBS course at Russia, my lord. For the medical expenses, he has paid the 30 lakhs rupees to the out of sale proceedings of the dwelling house, my lord. He remitted 30 lakhs rupees to the account of the respondent number 1 in order to prosecute for study purpose of MBBS course of respondent number 2, my lord. In this regard, my lord, this the same facts is stated in my at page number 11, my lord. In petition also stated the said fact, my lord. Considering the same, my lord, the trial judge has passed an order at maintenance has granted rupees 5,000.
Standing here,
Madam, this is a memo for posting.
who are you?
Ma'am, I'm case Madhvi Javagal Srinath, and hand summons was told.
Are you a party in person?
Yes, ma'am, I'm party in person. And
You
it's,
appeared before the party in person committee?
yes, ma'am, all that has been done. And I was in court hall number 20. It came for notice to respondent. I have submitted the notice to respondent, that file, but then it's been exactly 2 months today. The file has not moved. It's not been sent to the respondent yet. Also, what I gather is the respondent, I know that he's never in town. He's abroad, Javagal Srinath cricketer. He's always traveling all over the world. He's trotting the globe, and we never know when he is at home. So
Give some date, take that. Yes,
if you could kindly give me a
he'll
date.
come. Yes. What is the amount that is granted?
5,000 for respondent number 1 and 2, my lord. Respondent number 3 is son, my lord. He attained a majority. So trial court has not granted maintenance to the respondent number 3, my lord. My lord, at para number 4 of my petition, my lord.
1 minute. 5,000 to only the son.
Just a minute. Respondent to pay interim maintenance of rupees 5,000 per month to the petitioner number 1 and 2 from the date of this application.
You're saying that it is not granted.
My lord,
You said that it is not granted to the wife.
in respect of the petitioner number 3, my lord.
Who is petition number 3?
Son, my lord. Sanjay.
For 1 and 2, it is 5,000.
Please, my.
Yes.
Can you pass on without senior head up in another court?
Delete from Pater. This is matter on October 14.
Cell number 2, for dismissal, Ramesh KR, for petitioner, Rajesh P.
This matter came up on. What is happening? Why the parties are coming and representing before the court?
Ramesh,
Huh?
Ramesh,
ನಿಮ್ಮ ಲಾಯರ್
So?
number ಇವ್ರೆ?
ಅವ್ರು ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಹಾ.
ಲಾಯರ್ ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Expired, ಲಾಯರ್ is expired yesterday.
Your lawyer is no more. Ramesh KR.
Ramesh.
You want to engage an advocate or
ಎಸ್
legal?
ಕ್ಲೋಸ್ ಆಗಿದೆ, ಮೈಸೂರಿಂದ ಬಂದಿದ್ದೀನಿ ನಾನು.
Huh?
ಎಸ್ ಕ್ಲೋಸ್ ಆಗಿದೆ.
Take that. The petitioner is present before the court and the memo is submitted stating that the advocate died on 23/1/2025. Further, parties have entered into a compromise in before the National Lok Adalat on 9/3/2024, and also in the light of the joint memo that is filed, that is dated 16/3/2024, both the parties are residing together, the petition was accordingly the petition for restitution was dismissed. It is submitted that as they have served the dispute between the parties is settled, nothing survives for consultation. In this petition, accordingly, the memo is taken on record and the same is dismissed as a
ಟೋಟಲಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ರೀಫಂಡ್ ಕೋರ್ಟ್ಗೆ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ರೀಫಂಡ್ಗೆ ಟ್ರೈ ಮಾಡಿ ಅದು ರೀಫಂಡ್ಗೆ
the amount that is reposted for the trial court, the petition is at liberty to withdraw. Yes,
Then number 3, Syed Akbar Pasha for petitioner. Shivanand BS.
Respond. But I appeal for petition, Lord. Sorry, my Lord, the last date of hearing. But
Yes.
You were here. But
what is that?
not prayer, not the petition is before my Lord, the husband.
First of all, see,
Not enough.
lights are switched on, they're used.
Please, my Lord. But the petitioner, my Lord, is a husband. Well, writ petition, my Lord, seeking modification of the order, my Lord.
Where is
A visitation right.
Where is order?
My Lord, the order is at your lordship will get it, my Lord. At page number, it starts from my Lord.
Tell Bindu.
44.
that whenever
44.
the side advocate, whether the mic is properly kept or not, it is on or not, let us check. You check this side. Yes.
Lord,
page
the
number?
operative portion of the order is at page number 53. It is in Kannada. Lord, it means, Lord, a petitioner's second son, Lord, a visitation right has been given. That to Lord from every day 8 from 8 to 8:30 p.m. Lord, by telephonic call, WhatsApp video call, and then Lord, every fourth.
To pass an order, I should understand. The petitioner shall file the translated copy of the impugned order. By when?
10 days time.
This matter on 16, delete from dismissal. Yes, next.
Then number 4,
My lords, I appear for the petitioner.
Yes.
My lords, my client is a senior citizen. Since he was suffering from cancer, I had filed a application IA for adjournment in the trial court, honorable trial court. Now it seems that he has recovered from cancer, so there is no impediment for me to appear in the court. Anyway, I'll just secure papers, my lords, and I'll file a memo of withdrawal by the next date of hearing, my lords.
Why though not required? What is the petition will see? For that, a memo is not required. Where is
Please.
impugned order?
My lords, the impugned order is dated 22/3/2024, wherein
Page
the learned.
number?
One second,
Page number.
my lords. I'm sorry, my lords, I don't have the.
Nothing remains in this. When is
Please.
this petition 10/9/2024? A writ
Please.
of so and so.
Now he has recovered, my lords. Now he has recovered.
And apart from that, whatever the relief that you have
I
already
have got the relief from this honorable court, my lord.
the writ petition is filed seeking the following prayer. The writ petition is filed on 10/9/2024 without going into the merits of the matter, as already what the petitioner had sought for, given that 90 days time is elapsed. Hence, nothing
Please.
survives the consideration in this petition. Accordingly, dismissed.
Cell number 5 for orders matter. Awaiting service of.
Who is R2? When was the notice sent? Look at it. Then what is the await service of notice? Well, let them take the petitioner. The petitioner, the appellant shall pay the process within a week, or else the petition shall stand dismissed without further reference to the court. Yes, next.
Cell number 6. Cell number 6. Sanmati EI.
Yes.
Appearing for appellant, my lords.
Kumar.
I have paid the PF, which is notice for R3 for second time, my lords. And
When did
also
you
I have
pay?
paid the cost, my lords. I'll
When did you
file
pay?
today, my lords.
Today it's paid. It
I'll
is
file
submitted
the
that the needful is
acknowledgement for
done.
paying the cost.
And
my lords.
also, cost of 500 is already paid. This is matter of service of notice. Yes, next.
Cell number 7.
When is the notice
AM
sent? Look at
Venkatesh.
it.
I am for respondent number 4, my lords.
Who is respondent number 4? Claimant.
The claimant is 1 and 2, my lord. Await notice of respondent 1 and 2.
4 is whom?
4 is,
4 is,
When was the notice sent?
there's no liability on them.
4 is also employed under income tax department, my lords. Electricals, Raghavendra Electrical.
Yes.
ಇಲ್ಲ ರೀ 4 ಇಲ್ಲ ರೀ
13A?
ಯಾವ್ದು ಅವನ್ ಹೇಳ್ತಿರೋದು 4 ಇಲ್ಲ ಇದೆ
List is matter after service of notice. Yes.
Cell number 7. 8.
What is the service report of court notice?
Appearing for respondent, my lord.
Flag B.
It's already served. Huh? Look at flag B.
My lord, appearing for R1, my lord.
They say it's flag B, they placed it. Hmm? I am directed to send you to someone who is from the registrar. General High Court service. So for service on the prayer number. Kindly to get someone who is served for orders. Seeing authority. Initial complaints. Right. What is this in Hindi it is? notice served. As for as for the orders passed by the court, the notices are served on the appellants, duly served on the appellant, mentioning that the matter is coming up before the court. In spite of the same, no wakalat is filed on behalf of the appellants. This is matter for dismissal tomorrow. Yes, next.
Till number 9.
One submission, my lord, in the previous matter. My lord, I have not received the copy of the appeal memo from the previous advocate. I have to file wakalat. Otherwise,
Who will give you papers when the parties are not represented?
My lord, in fact, I've informed the trial court advocate, one Mr. R. Chandrasekhar.
It's already served. It is already served. It is over.
I understand.
Yes, 9.
Till number 9.
First respondent.
A correct.
What is that? Let's see, is there anything, it's a case for enhancement?
Pass over.
Pass over, yes, pass over. Yes, 10.
Till number 10.
Memo is filed seeking dispensation of notice to R1, dispense with at the risk of appellant. I number 2 of 23 is filed to condone the delay of 162 days with filing condoned on condition. Yes, ready?
Not kindly post along with another 3 connected matters.
Post along with so and so
Please.
on 9th of September.
Please.
Yes, next.
Till number 11. 11. Anwar Ali.
Raise time for the, I have to file the translation copy, raise time.
Of what?
For the depositions and all, last time,
They're all not required. You can argue.
my lord, is senior counsel is not there this time.
If the translated copies are required, the court, the translated copies are not required, the petition, the appellant shall go ahead with the arguments. Let's just matter on 10th of September.
Much obliged.
Till number 12. Till number 12. G. Narayana Rao for petitioner.
For acceptance of paper publication. And for the petitioner.
Same. Accepted a notice to which respondent? Sole respondent. The respondent is held sufficient. This put in the name of the party. Admit post for final hearing. Plus 13.
Till number 13.
Much obliged.
My lord, insofar as the copy
Certification of office objections raised on objections to IA.
that is filed by the respondents, insofar as the copy that was not being served regarding contempt that is filed by them, we have received the copy, my lord.
Rectification of office objection raised on IA number 2 for direction to initiate contempt proceedings. Who filed this?
Filed by the respondent. My lord, that IA may have to be withdrawn. There are some technical issues. That's an IA that has been filed where they're seeking for initiation of the contempt against the respondent. I believe there is a typographical error in that.
That has been rectified, Your Honor.
Each page not signed by the council, affidavit not forthcoming. Why those kind of,
Affidavit was signed by each page, ma'am. Affidavit is signed.
Look at it. Look at it. Pass forward.
My lord, just one submission, my lord. If this honorable court may kindly have the matter on Saturday, I'll keep the mother and the child present, my lord.
Saturday.
Much obliged.
At the request of non-counsel, the petitioner lists this matter on Saturday, on the day both the child. No, on that day it is not possible. List it on Friday. On that day they shall be present.
My lord, Friday, the child still has an exam going on. So Evening, evening 4.
5:30.
Much.
Cell number 14. Sumangala
I've
Swami.
heard the copy on the council appearing before this one, my lord, and also paid the amount on 15th this one.
Now taking of hand summons on R1 to R3.
Pardon?
You have taken hand summons on the council.
The second respondent is a minor, so represented by mother. So I have given to R1 and R3, I have taken this one, my lord. And also
the memo?
Hand summons has been paid. Hand summons has served on the council.
Office objection is you have not taken hand summons.
No, here it is, I have taken. On 14th only I could serve because I served on 14th, my lord.
The petitioner submits that as per the order passed by this court, the hand summons are served, but no memo is filed.
I will file the memo tomorrow.
Petitioner shall file the memo. Once the memo is filed, is the matter. Yes.
Cell number 15.
For respond.
IA number 1.
That is dated 24/4/2024. I filed an application for recall of the order dated.
IA number 1 of 24 is filed to recall the order dated 13/8/2022. Today a memo is filed seeking to withdraw the said IA. Accordingly, memo is taken on record and IA is dismissed as withdrawn. Then what do you say about delay, Mr. Vijay Kumar?
My lord, there is enormous delay. I have not received the copy and also know the reason for the delay. And even copy is also, appeal memo copy is also not served.
Submission. By order dated 13/8/2022, the petition, the appeal came to be disposed of before the Lok Adalat. Now the content is taken by the.
Whatever it is, give it to him. Papers you have.
Yes, it is given to him. Copy is given to him. No, what happens, my lord? The case is disposed of. So if by recalling this, withdrawing this application, the case is also disposed of.
So you wanted to recall that. So then that order will be.
Yes.
Will
So
come into force.
with liberty for me to proceed as per law. With liberty to proceed as per law. Now, my lord, 13/8/2022, before the Lok Adalat, this MF came to be disposed of. Now I filed an application to recall that order. Now the respondent is telling that this application is not maintainable. So I am filing this memo to withdraw this application with liberty to proceed as per law.
What liberty? When is this order passed?
On 13/8/2022. Now I have to file a writ petition.
Remove that. IA number 1 of 24 is filed to recall the order dated 13/8/2022. Now a memo is filed seeking to withdraw and also seeking a liberty to avail the appropriate remedy. The matter came to be disposed of before the Lok Adalat.
Awarding 50,000 rupees, my lord.
13th of 2022. Now this IA is filed to recall the said order. Then council submits that he will avail the appropriate remedy. This order is passed on 13th August 2022. The petitioner is at liberty to avail the appropriate remedy subject to the law of limitation also.
And also, my lord, is not entitled for interest for this period because unnecessary matter is being dragged in spite of the disposal of the matter.
No, I'm not saying anything. That the court will decide wherever he files an application. Yes. Please, that only is dismissed from. Delay we are not considering. Next.
Cell number 16. Cell number 16, Satish Chandra.
Appearing for third respondent.
IA number 1 of 23 is filed to condone the delay of 11 days. Condone. Yes, ready?
Hello, sir. Statement.
To whom?
Liability fixes owner of the vehicle. Is appearing for owner and.
IA number 1 is filed to condone the delay of 11 days. Delay condoned. Admit. Hearing call for the DCR. So.
Arising out of same accident.
Drop that. Yes.
Cell number 17. Trivikram S. For petitioner. Udita Ramesh.
As Lordship have informed me to take status of the child because there was a report submitted by the
before the trial court, my lords. On the basis of report, the visitation raised was stayed by the trial court. That impugned order has been challenged before this court. The child has gone through several counselings, etc. Now, lordships asked me to verify what is the status of the child and what counsel he is taking. My lords, as per the doctor's suggestion, the child is he's playing chess, he's going to music classes, he's going to
Where is
yoga,
that report?
etc.
What
Chess.
is, where is your, you filed some objection?
I have filed objections.
Hmm.
In that objections, I have placed the report of earlier.
There are office objections on that.
There's now matter before.
Comply with the
Preamble
office objection
submission, my lord.
within a week.
Well,
Last date of hearing, please, my lord. After hearing both sides, my lordship has directed the other side to file a report. Present conditions.
What he says, he has placed a report. There are
Present
office objections on that.
Please, my lord.
To comply it within a week, or else the objections shall not be considered and the matter will be heard. List this matter after 1 week. Yes, next.
Cell number 18. Bhargav D. But for petitioner.
I appeal for the petitioner, my lord.
Where is the respondent?
I am for the respondent in this matter. In the connected matter, I am the petitioner, your lordship.
This matter, my lord, the first matter we had filed because an application seeking interim maintenance was not decided by the Honorable Trial Court. It was in excess of more than a year. My lords had in fact called for a report from the concerned court regarding the pendency of the IA for a prolonged period.
With your lordship's permission, the connected matter.
1 minute. Yours is WP?
WP 16014 of 25, my lord, the first petition.
The petition is filed.
Lordship, if I may, in this matter.
Yes.
Lordship, the connecting matter which is there in the prior to this IA, which is the writ petition, which is 13430, which is the connected matter, we had for rejection complaint order 7 rule 11 of CPC read with 150.
The writ petition is filed. How can they, is it an order posting a matter? How can such a relief be asked? The writ petition is filed with the following prayer. It is a case that the MCs of the year 2023 and the IA is filed seeking maintenance in the year 2023. So far it is not disposed of. Then this court has called for a report from the concerned court. As per the report reveals that the respondent before the family court has filed an application to reject the plaint on the ground of that the court has no territorial jurisdiction, as the same was pending consideration and the same was disposed of in the month of March. Till such time, as that goes to the root of the matter, they could not pass any order on the interim maintenance. And now when the application, when the court is ready to take up the matter, a memo is filed before the court stating that the matter is pending before the High Court. As such, the same was not considered and orders are yet to be passed. The whenever an IA is filed seeking injunction, seeking the interim relief of maintenance, the court has to consider and pass orders as expeditiously as possible. If another application that's filed for rejection of plaint, that could be considered in the due course. And for that, for 2 years, the applications of this nature, which is for the immediate requirement of the parties, cannot be kept pending. In that view of the matter, this writ petition is disposed of, directing the court to decide the IA within a period of 1 month from the date of receipt of the copy of the order.
Lordship, if I may.
Yes,
It was
next part of
2024, Your Lordship, and the matter posted for
Please
mediation.
come to, no, let it complete within 1 month. 18.1, what is it?
18.1, if I may, Your Lordship.
Yes.
We have filed for rejection of plaint. The same petition is with Your Lordship.
When is the impugned order?
The impugned order is on page 41 to 47, Your Lordship. Page 45. Page 45, Your Lordship may kindly see from 12th para. Page 44. The reasons for dismissing it from para 9 to para 13, Your Lordship. If I
Yes, what are your submissions?
Lordship, to the extent of it, after 40 years, this they have filed this petition. That too, if Your Lordship may kindly see in their petition also, in their main MC also, that they said that they reside the wife was born and brought up in Calcutta. Then later on, she stayed at Hyderabad for 40 years, and now she's come to Bangalore, wherein her son resides, but she's taken a separate residence and filed it. So on 5/8, as per their document only, on 5/8/2023, the wife left from Hyderabad to Bangalore, and then they issued notice within 16 days, sir. And they have created documents to file this. So territorial jurisdiction is not maintainable. That is our contention.
Yes.
To the extent of it, if I may, Your Lordship may kindly see, their petition is on page 15, sir.
Yes.
Page 15, para 3, 4, 3, 5, and 6. If I may be permitted to read, Your Lordship. The petitioner and the respondent had married to each other for the past 40 years. The marriage between the petitioner and the respondent was solemnized on 9/5/1983, according to so-and-so at Jaswal Garden, Hyderabad. They are saying that the marriage took place in Hyderabad. Prior to that, 5 and 6 is
I don't think it requires that such an elaborate hearing. I understood what your contentions are. I've
Yes,
seen
sir.
the order of the court. Yes, please come.
Lordship, one last submission, if I may. One last submission.
Yes.
Lordship, to the extent of it, the previous writ petition also, because they are arising out of the same MC. On last date of hearing, on 3/6, my present petition was filed. On 3/6, they also filed the writ petition. No notice was served upon me also. Apart from that, on 3/6, there is no mention of this matter being connected. Again, in the month of August, that is on 6/8, when this matter was listed. When I had filed this present writ petition, the other side counsel appeared and said that we want a settlement. And Your Lordship may kindly
matter disposed of one. Though the respondent is the respondent has the husband has filed WP number 13430 of 2024, and so far no notice is issued to the respondent. Disposal of the petition is in the interest of both the parties, and this court is not proposing to issue any notice to the respondent. Then WP number 13430 of 2025 is filed, questioning an order that is passed
Lordship,
by the
last submission. I'm sorry, Your Lordship. The matter
this
was
is nothing but to drag on the proceedings. On this, the cost should be imposed on this petition. The
Lordship,
MC number 7646 of 2023.
Lordship, if I may,
Agreed with I number 3, in MC number 7646 of 2023, dated 11th March 2025, whereby an application that's filed under Order 7, Rule 10 and 11, read with Section 151 CPC came to be dismissed. The wife had filed the petition
The matter is posted for mediation.
the
In fact, your lordship had counseled both the parties.
that is not, now for that purpose, the matter will not be kept pending like that.
Yes,
And
yes,
again, MC number 7646 of 2023, seeking divorce. In that, she has filed an IA seeking maintenance, and the husband has filed the IA number 3 under Order 7, Rule 10 and 11, seeking rejection of the plaint. It is the case of the husband that the marriage has taken place, takes place in Hyderabad. And by creating a rental agreement and Aadhaar card for the, she has created a rental agreement and Aadhaar card for the purpose of filing the petition. According to him, the wife is continued to reside in Hyderabad till 5/8/2023. And it is stated that prior to the filing of the present case, she is residing with the help of her elder son in a rented house, as shown in the cause title. According to the husband, the present MC is not maintainable before the family courts at Bangalore, and the family courts at Bangalore have no territorial jurisdiction to try this MC. The court had considered the contentions of the respective parties, and particularly Section 19 of the Family Courts Act, the Section 19 of the Hindu Marriage Act, and considering the same, the court has observed that the documents produced with the wife prima facie discloses that she is a resident of Bangalore as on the date of presentation of the case and onwards, and the petition before the family courts at Bangalore is maintainable. Next para. Learned counsel for the petitioner has reiterated the very same grounds that are raised before the family court, and submits that the present petition is not maintainable. Learned counsel for the respondent has supported the order passed by the court. Having heard the counsel, this court has perused the material. When an application is filed seeking rejection of the plaint, the court cannot consider any other material, but can only look at the plaint alone. The plaint reveals a cause of action, and according to her, she is living in Bangalore. And Section 19 of the Hindu Marriage Act gives the choice to the wife to file the petition where she is residing. Whether the said Aadhaar card, the rental agreement, they are concocted or they are created for the purpose of this petition and all, the court cannot decide. And the material on record, as per the plaint, reveals that she is residing in Bangalore. In that view of the matter, the courts at Bangalore have jurisdiction to entertain the petition. In that view of the matter, this court finds no reasons to interfere. Dismissed.
Please.
Till number 19. ANTR for petitioner.
Appearing for the petitioner, Your Lordship, who is a husband of respondent number 2, Your Lordship. Initially, the divorce petition was filed by the respondent.
What is the impugned order?
Your Lordship, the family court has directed the respondent, this petitioner, to pay 7,000 towards interim maintenance and 2,000 towards litigation expense, Your Lordship, which is at Annexure A.
I've seen. What's wrong with that?
Your Lordship, the respondent, she is having double degree, Your Lordship, and having medical of her own. She is earning out of it, and there is no issue between.
Where is the material? Have both of you filed your statement of assets and liabilities?
No, Your Lordship. Without considering the assets and liabilities, the trial court has passed the maintenance, Your Lordship.
Where is that material?
Please, Your Lordship.
Is it your case that you have filed and court has not considered?
No.
Or court has not even looked into the...
The court has not even looked into the...
You have not filed?
No. Neither petitioner nor the respondent has filed the assets and liabilities.
MCs of the year 2023.
Please, Your Lordship.
This order is passed on 27th February 2025.
Please, Your Lordship.
Which court is this?
Srirangapatna.
Senior Civil Judge and JMFC at Srirangapatna.
Please, Your Lordship. And they have made observation that the petitioner, at page number 14, Your Lordship, the petitioner is educated and she is having a degree of MCom, and she is also working in the private company, having a good salary. In spite of that, they have ordered 9,000 per month as a maintenance. I have furnished the salary documents of respondent, Your Lordship, petitioner, Your Lordship, which is at page number 20 to 26, annexure F. He is earning 20,000 in an average, Your Lordship.
Please come. The present writ petition is filed, agreed with orders passed in I number 1 in MC number 55 of 2023, passed by the Senior Civil Judge and JMFC, Srirangapatna. The learned judge has granted maintenance of an amount of ₹7,000 per month from the date of application until further orders. This court has perused the order. In spite of repeated directions by the Honorable Apex Court and also by this court, the courts are not at all following the law laid down in Rashish versus Neha. The entire order do not reveal why that the court has referred in the entire order. The court has not referred to the statements of assets and liabilities. The court goes on the aspect that an able-bodied person has a obligation to maintain his wife. Why the learned judge has not directed the parties to file the statement of assets and liabilities, and in spite of clear circulars issued by the High Court, why such exercise is not done by the court? The Principal Senior Civil Judge and JMFC Srirangapatna shall place a report before this court. This is matter on 10th of September. By that time, the report shall be placed before the court. Till such time, the appellant, the petitioner shall pay. There shall be stay of all further proceedings on the condition of depositing half of the amount and arrears also at the same. If the amount is not paid, the stay granted by this court stands vacated without further reference to the court, and shall take out hand summons on the counsel appearing for the respondent and file a memo to that effect by September 23rd. If that is not filed even on the ground, the stay granted by this court stands vacated. List this matter on the 10th September.
Till number 20.
Grateful, Your Lordship.
Akmaha Devi.
My lords, I appear for the petitioner in this, my lords. This is ex-husband's petition. Both are divorced in 2019, my lords. So that is on 31/8/2019. Now the issue is only with regard to daughter's education expenses, my lords, and also maintenance. My lords, this honorable court, when the matter was pending, MC was pending before the court below, there was 5,000 maintenance ordered. Later, my lords, what happened was that was challenged with a petitioner hearing before this honorable court, but this honorable court increased the maintenance to 10,000 per month and also education expenses. My lords, without taking into consideration, she is also a software engineer. In fact, she is earning more than the petitioner now. She is also now remarried to a doctor. He is also married now. He is also having a child and he has to take care of his parents. The issue is this, my lords. Kindly see, my lords, page 142 is the impugned order, annexure J. The execution case is filed by the petition respondent, that is through mother, which was pending before the learned executing court before the Mysore, which was transferred to this honorable here to Bangalore, because both are now residing in Bangalore. My lords, what the objection is here is education expenses for the academic year third and fourth, which come under during COVID period. My client, that is a petitioner herein, requested for original fee receipts from the school, because whooping sum of 2,17,000 is claimed by her. What my petitioner is saying is, during that time there was no lab fee, there was no capital expenditure fee. Kindly see, my lords, all bills she has given only the Xerox copies. Kindly, one instance I may be permitted to show, my lords. Page number, my lords, 81 may kindly be seen. Page 81. My lords, annexure J.
Where are your objections?
My lords, my objection is annexure D, which I have filed.
Page number?
Yes, yes, my lords. Annexure D, my lords. Page 32, before the court below. Kindly see, my lords, paragraph I may be permitted to read. Page 33 is the relevant, which continues. The amount mentioned in para 7 of the petition towards educational expenses of the degree holder is exorbitant and absolutely false, in view of the fact that almost all educational institutions in the state have generally exonerated the tuition fees of the students in view of the shutdown of the schools due to COVID-19 situation in the entire state for the academic year 2021-22, particularly in Mysore city, where the COVID cases reached its peak. Under such circumstances, the claim of 2,17,000 made by the decree holder is absolutely false, and the natural guardian of the decree holder is trying to make out a wrongful gain from the judgment data. My request, my lords. May I request, my lords? My lords, he is also now remarried. She is also married to a doctor. We have about that, there is this. If notice is issued, if she is going to settle this, because she is earning, he is earning less than what she is earning, my lords.
Can the court decide that in execution petition?
No, my lords. What we are saying is, if my lords make little,
we can't. That is beyond the scope of jurisdiction, as vested with the
my lords, only thing is, he is ready to pay the lump sum amount. Now his maintenance he is paying, my lords. As such, maintenance he has not even stopped.
No, if both of you are agreeing on something, it's fine. But court cannot pass any order.
That endeavor may be, my lord, because he is going through a bad
correspondence.
My lords, stay may be granted only for the third and fourth standard fee, my lords. Maintenance he is paying. My lords, that part, my lords, we do not, we are not even.
Take out notice on the council. Whenever you file the memo, the matter will come. When the court is not convinced, we can't. I can't grant a stay.
No, my lords, my
respondent petitioner is permitted to take out hand summons and file a memo to that effect. Once a memo is filed, it's the matter.
Till number 21.
My lords, we are permitted to serve the copy on the council for the.
That's what I said. Yes, that's what I said. Hand summons on the council.
Oh, obliged.
Lord 21, I appear for the petitioner.
Yes.
Because I had sought time to produce the audio transcripts in this amendment application that I had filed, my lords. The audio transcripts are all in Malayalam. Hence, I'm not able to get it translated and produced.
After 2 weeks, at the request of then council for the
petition.
Yes, next.
Number 22.
Appear for the petitioner, my lord. This is wife's petition, my lord.
For enhancement.
Yes, ma'am.
Wife's petition for enhancement.
Not enhancement. It is for custody of the child, which is presently aged 2 years, 2 months old, my lord.
Where is impugned order?
Impugned order, your lordship find at page 11, and the operating portion of the order, the lordship find at page 22, internal page.
The respondent is directed to hand over the minor child to the interim custody of the petitioner on every Monday, Wednesday, and Friday from 9 a.m. till Further orders.
Because they are staying at a distance of 35 kilometer apart, my lord. And the petitioner is also, she is working for Aditya Birla company, my lord. And the respondent is a lineman working in Bangalore Power Supply Corporation, my lord. And now, because the distance is 35 kilometer, to pick up the child in the morning at 9 o'clock and to drop at 5 o'clock is very difficult, my lord. So my humble submission to your lordship is, let a week's custody, we have no objection. Let the respondent husband want to have the custody, he can have the custody. But the thing is, my lord, continuously a week custody may be given at present, my lord, till the petition is disposed.
Mother has no objection for that.
No, we have no objection. We want the custody
Who
of
stays along with the father?
father, his aged parents, more than 75-year-old. As far as the
Who
petitioner,
has filed GNWC?
this mother of the child of presently 2 year, 2 months old.
She filed the GNWC.
She filed the GMWC by through the.
We'll pass orders once the father is here. Notice to the respondent, same hand summons. Once the memo is filed, is the matter.
And hand summon, I will take it out to the advocate appearing before
Advocate.
trial. Yes.
Yes.
Very good.
For admission matter, serial number 23, Srinivas DC for appellant, A.
Here on
Venkatesh.
behalf of the counsel for appellant, my lords, the arguing counsel is not keeping well. A short date may be given, my lords.
No short date.
Any date.
This is matter on 22nd of September.
Great.
Serial number 24,
The request of non-counsel to the appellant. Yes.
24, Renuka HR for appellant.
The case has been dismissed, my lord, abated, my lord, on the ground that the claimant is no more. And I've not been able to take steps, my lord. If your lordship could, my lord, I'll just, my lord.
Appeal against R1 stands abated. R1 is the claimant.
R1 is the claimant, my lord. So, my lord, I've asked them to furnish the particulars, my lord, since.
When was this? 33, 2023?
23, my lord. Probably, my lord, I had
Then
not.
2025.
I think, my lord, I had not informed them, my lord. Today I have informed them, my lord, immediately after.
Finally, 4 weeks' time is granted for taking steps, or else the petition appeal shall stand dismissed without further reference to the court.
Serial number
Yes, 25.
25, R. Shashidhara for appellant.
Third
Ramesh
respondent,
Denny.
please.
Yes.
Fracture of maxilla and other facial injuries, my lord.
Come to the table.
Yes. Page number 7 of the judgment.
Page number
7 of the judgment. Pain and suffering awarded 50,000.
What are the injuries? Where do you get the injuries?
Issue number 2, my lord. The petitioner, in order to prove the permanent physical disability, has examined the doctor. PW2 is not treated doctor. He has issued disability certificate as per issued P9. According to evidence of PW2, the petitioner has sustained fracture of maxilla bone. On clinical examination of the doctor, assessed disability to the accident to 35%. In cross-examination, as categorically admitted, he has not taken the X-ray of the fractured bone. He has examined the petition only on 11/64/19. He has not taken any opinion from the dentist. And
So under which head it has to be enhanced?
But disability, my lord, some
Without taking any X-ray, without doing any exercise, how can you just like that given that has to be considered?
medical evidence is clear that my lord, she said injury to the maxilla and
There is
other
a
facial
procedure.
injuries.
There is a procedure
And
to
he was
assess
taken.
it.
Yes, ma'am. He was taken treatment for a period of 3 days as inpatient, my lord.
Loss of femininity is
5,000.
what do you say will increase it on
Please.
how much?
You told us.
And the 50,000?
In all, please. Please. 5,000 conveyance and charges.
We have agreed in the local
Cost of
for
in-
46,000.
Huh?
We have agreed before the local 46,000 is interest. The learned council of appeal are
1,000.
not agreed
In addition to that,
in whatever granted that.
it can't. Then I'll say that the insurance company is
46,000, please.
in addition to what has been
Please.
awarded. Yes. Please come. Agreed with the award passed in MVC number 16 of 2018, dated 6th November 2019, whereby the tribunal had granted 74,918 The claimant is before this court seeking enhancement of the compensation. According to the claimant, he had sustained fracture of maxilla bone, and according to the doctor, he had sustained disability of 35%. The court had disbelieved the said evidence as the disability was not assessed as per the settled procedure, and he has not taken any X-ray, and that opinion is not basing on the X-ray. And court had granted an amount of rupees 74,918. Then counsel appearing for the petition of appellant claimant submits that when he has sustained 34% of disability, court ought to have granted the considered the disability, and basing on that the compensation ought to have been granted, and as such the amount needs to be enhanced. Then counsel appearing for the respondent insurance company submits that in fact they are in the Lok Adalat, they were ready to pay an amount of rupees 46,000 in addition to what has been paid, what has been granted by the tribunal with interest, but claimant globally or with interest?
Globally, please.
Globally at 46,000, but the claimant was not interested for the same. Next part, how the counsel saw neither said peruse the material on record. The as sought for by the appellant, the disability cannot be considered as the doctor has not assessed the disability as per the, it is as per the procedure, and just like that he has considered the disability, and the tribunal had awarded the amount. In these circumstances, when the insurance company is ready to pay 46,000 in addition globally, in addition to what has been awarded by the tribunal, this court is of the view that the appeal can be disposed of. Appeal can be partly allowed by enhancing the compensation of by granting compensation of 46,000 globally, in addition to an amount of 74,918, which is already awarded by the tribunal. Yes, accordingly, the appeal is partly allowed.
Cell number 26.
Yes, 26.
Reader DS for appellant.
Appellant's counsel, my lord, in this case of death, my lord, the contributor negligence was 10% is challenged by me, and also monthly income is ought to have 12,500.
First, what we do is we'll calculate the compensation, then contributory negligence. We'll look at the order. Please come to the table.
Table is page number 15, my lord.
What is the age?
Age is 54. Multiplier is 11.
Year?
Year of accident is 24/7/2018.
As per the table?
12,500.
What was taken?
10,000 taken. And
is it your case that you're earning 10,000?
Pardon?
Is it your case that you're earning 10,000?
Well, 10% has to be removed.
No. What is your case?
Case, my lord, contributory negligence.
About the income?
Income coolie. So it's.
What did you say before the court?
Court is, I've said 25,000 per month.
So 12,500. Any future prospects?
10%. That is 13,750. Into 12 into 11 into 3 by 4.
One submission, my lord.
Yes.
Yes, I am for the appellant, my lord. My appeal is also there. My lord, I have challenged the negligence aspect, my lord.
We will consider that.
Please, my lord.
How many are the dependents?
Dependent 4 members, my lord.
Out of them, 3 are major married children. They are not depending upon income of the deceased. Criminal is not considered.
My lord, daughter is depending upon mother because husband left already. She's,
so how many? 1/3 has to be deducted. 1/3 has to be deducted.
1/3 is deducted,
1/4
but
has to be
50% will have to be
1/3 was
deducted.
deducted.
Because wife is
1/4
only
has to
the
be.
claimant. Wife is only the claimant.
Now, as you say, Ken Ganesh, what is he doing?
The cooling.
All are major.
Actually, my lord, all are, according to evidence, all are depending upon the father. And there is no suggestion regarding that they are not earning anything that is there. Leaving it apart, my lord, daughter is staying along with mother because of her husband left. She is purely depending upon the mother now because father died. So, tribunal
There is
taken
no evidence in
1/3
this
as
regard, and they have not examined the petitioners number 2, 3, and 4 to show that they are depending upon the income of the deceased. Absolutely no evidence from there.
1/3 was deducted. My request is 1/4.
In the class examination, we have suggested that they are not depending upon income of the deceased. It is very clear.
What is the judgment of the Supreme Court?
Supreme Court says
Justice Mishra's judgment. Some Sheetal or something is there.
They have to prove their dependency by cogent evidence.
Not Biren, the latest judgment is also there.
Latest judgment also, not.
It's there with us. Justice Prashant Kumar Mishra's judgment. Now please come to the contributory negligence.
10%, my lord. What is the one fatal suggestion by the respondent in the cross-examination of eyewitness that I'll read out? The place of accident is on the turning road. I cannot say the.
No. Please come to the finding of the court with regard to the contributory negligence.
Para number 11, my lord.
Please read.
I have given careful consideration to the points urged by both sides. PW2 is an eyewitness. PW2 is not relative to the deceased. At the time of accident, he was working near the spot of the accident. He has seen the accident from the place where he was working, whereas RW1 is an interested witness. The police have already filed charge sheet against him. A criminal case is pending before the criminal court. Under these circumstances, it is inevitable to RW1 to say as this accident was not occurred on his negligence, whereas PW2 is an independent eyewitness. He has faced searching cross-examination, but nothing was elucidated to disbelieve his evidence. Now we shall turn our attention to Exhibit P3, which is a rough sketch of the Exhibit P3 speaks that there is a little turn where this accident was occurred. BMTC bus was moving from the northern side towards southern side, but the two-wheeler of the deceased was moving from southern side towards northern side. Exhibit P3 speaks that a driver of the offending vehicle had enough scope to avoid this accident either by taking his vehicle towards his left side or by reducing the speed of his vehicle. This accident would have not been occurred if he had taken his vehicle towards his left side. There was sufficient space towards his left side. There was enough chance to him
With it,
to
I've
take
seen-
his vehicle towards his.
Seen it, what is wrong with it?
Pardon?
I've seen it, what is wrong with it?
And my lord, one of the suggestion in the cross-examination is very clear. The place of accident is on the turning road. I cannot say in the night hours the rider of the offending vehicle could not able to see ahead of
What
his
time is the accident?
7:30 evening.
Hmm.
So they themselves suggesting that we can't see the vehicle coming from the front side. That is, I cannot say in the night hours the rider of the offended vehicle could not able to see the head of his two-wheeler in the headlight of the opposite vehicle. So he himself is giving suggestion in the cross-examination to the PW2 the witness, saying I am unable to see the vehicle. That's why I dashed it. That also taken has to be fatal for their this one defense. So contributory negligence has to be removed, my lord. That's the one.
Yes, Mr. Vijay Kumar.
Please, my lord, your ask me kindly see before going to the evidence of PW2, kindly see, my lord, exhibit P3, the spot sketch, my lord.
Spots
Exhibit P3.
These are not brought.
Yes.
Exhibit
Yes,
P3.
yes.
My lord, the width of the road, my lord, is about 15 feet. And my lord, the bus is about 8 to 9 feet width in the this thing. The bus is on its correct side of the road, on the extreme left side of the road. And accident has taken place after the median line, and the came and dash taken is the front portion of the bus. And there was, from the place of act, there are 7 feet wide road for the rider of the scooter, Kinetic Honda, who came from opposite direction. When he was taking left turn, my lord, he lost balance and came to the right side of the road and dashed against the bus. And apart from that, my lord, there was a bus stop just about 30 feet away from the place of accident. The bus is, in order to go and stop in the bus stop, in order to alight the passengers, it was completely on the slow side. And it is only the rider who came from opposite direction, though there was a lot of space on the left side of the road. He lost balance, came to the right side of the road, and he came and dashed against the front portion of the bus. It is a head-on collision. And my lord, kindly see exhibit P6, my lord, IMV report. What are the damages? Which place of the damage is caused? When the bus is on the extreme left side of the road and there is no place at all as per sketch. Kindly see, my lord, vehicle number KA57F2674, front right bumper damaged, front right side corner shape body damaged. My lord, this clearly shows, my lord, bus is on the left side of the road, correct side of the road. And though there is a lot of space on the left side for the motorcycle, he came and dashed against our bus. And when bus is approaching the bus stop, it cannot go fast. And the evidence of PW2, my lord, kindly permit me to read only the cross-examination portion. I do not know the LRs of the deceased. I do not remember the date of accident because he is not a complainant, he is not an eyewitness. He is only a punch witness, he came later. My lord, this accident has occurred in the evening at about 7:45 p.m. I am a mason. I am going to close my work by 5:30. When he is close his work in 5:30, how he can see the accident at 7:45 p.m.? Then, my lord, there was 1 minute, I'll complete the cross-examination, then you can. My lord, there was 150 feet distance between the place of accident and my workplace. It is true that there was a turning where this accident has occurred. On that day, I was walking on my left side of the road, but which direction he has not stated. There are many passengers in the bus. There was a bus stop just 30 feet away from the place of accident. This is more important. It is about 30 feet away from the place of accident, bus stop. How the bus can go such a fast and hit against the rider of the motorcycle? He was about to stop the bus. That is on the extreme left side of the road. Then, my lord, it is true that all BMT buses are going to stop in the said bus stop for the convenience to the passenger. It is true that bus was moving on its left side. This is more important, my lord. It is true that the bus was moving on the left side of the road in order to stop in the bus stop. What more is required, my lord? Then, my lord, it is correct to suggest that in order to stop the bus at the bus stop, the driver had reduced the speed of his bus. Witness volunteers report that on that day, bus was running at a high speed. There is 115 feet distance between myself and the offending bus when the accident has occurred. It is incorrect to suggest that it is not possible to see the two-wheeler and it is not possible to see the two-wheeler and I cannot say how it came and what speed. Well, he has not seen the vehicle at all and he cannot say what speed it came. I know how kinetic came. The kinetic Honda came in a normal speed. It is incorrect to
So,
suggest that.
whenever the cross-examination says something which supports your case, that has to be looked into. And the part of the cross-examination, what he says, then he is not an eyewitness. Then you shouldn't rely on his evidence at all.
Then where is the eyewitness, my lord? Then how a court can take into?
No, that's what I'm saying. You can't rely part of his evidence saying that his evidence supports your case, saying that there is a bus stand, bus is going slow. Either he's a wholly, only a reliable witness or not a reliable witness. You can't know. You can only say that the evidence of PW2 cannot be considered because he is not an eyewitness according to you.
But he has described about the place of accident because he is from that locality. My lord, he may not be an eyewitness, but he is from same locality. He is working in about 150 feet away from that place, and he can describe the place of accident.
Mr. Vijay Kumar, law of evidence says something. You cannot take the evidence like that. We can't consider the evidence in that manner. What you are saying,
my lord, the entire evidence clearly shows, my lord, because here, my lord, the accident is not in dispute. Involvement of the vehicle is not in dispute. Only the dispute with regard to who is negligent.
According to you,
where accident has taken place. Where accident has taken place.
Please make yourself very clear whether PW2 is an eyewitness or not.
Lord, even assuming that he is an eyewitness.
I am asking you, not assuming. I am asking you a question.
His entire evidence is in our favor. His entire evidence is
so
in
you
our
agree that he is an eyewitness?
Yes, my lord.
Yes. Now you can make submissions.
Yes, my lord. My lord, he says the bus was on the extreme left side of the road.
Yes.
But bus is going to stop in the bus stop.
Yes.
He cannot say the speed of the bus. He says he was coming slow. My lord, if really is coming slow, the motorcycle, then my lord, he could have gone on the left side of the road. Why you should go on the other side of the road and dash against the bus? My lord, sympathy is there. My lord, sympathy cannot be considered for all purpose. When he is totally negligent, sympathy will not come into play.
Yes.
Therefore, my lord, the tribunal, taking into consideration of evidence of PW2, Exhibit P3 spot sketch and Exhibit P6, my lord, IMA report, there cannot be any negligence at all on the part of the driver of the bus. Still, my lord, because when we take into consideration of the sympathy, he is totally negligent and responsible for the accident. Therefore, 50% contributing negligence will have to be fixed on them.
Yes.
That is my submission. Because the entire evidence of PW2 is in our favor.
Yes.
There cannot be any negligence on the part of the driver. And we have also examined the driver also. Yes. He has also clearly stated that he was driving the bus carefully.
Yes,
and
you can argue. Yes.
My submission is like this, my lord. He is himself claiming that his work was over around 5:30.
Forget about all that. The important issues in this evidence are, no, the bus is on the extreme left side. There is no dispute on that.
My submission is like this one. It is undisputed fact is it was a curve.
Huh?
Accident occurred at the curve. Curve. So bus can't go straight away at the extreme left. He has to little bus is big only. So he has to take little right turn only, not the left turn. Extreme left he can't go. Another aspect, he himself in the cross examination suggests.
So while he was taking a U-turn, this has happened.
Yeah. Curve.
Right turn, not U-turn. Right turn.
It's an undisputed fact that it was a curve. U-turn not like this, my lord. It's like bend.
No, while he was going like this, he is coming on the other direction.
Yeah, opposite direction. So, and also his cross-examination suggestion also what I already read is it was heavy traffic road. The place of the accident is on the turning road. I cannot say the night hours. The rider of the offending vehicle could not able to see the ahead of his two-wheeler in the headlight of the opposite vehicle.
Even when the
My lord,
bus
one
is,
sub-
no, no, 1 minute, when the bus is taking a right turn,
Yeah.
definitely while he's taking a turn, he must not be going in a high
There's a
speed.
20 feet width road, my lord.
That's what that means. The
15
was
feet,
coming
not 20 feet.
disease was coming in a high speed.
No. This is his clear the suggestion in the cross-examination. Driver was not able to see the opponent vehicle, and apart from this, my lord, the driver he has not given complaint to the police immediately. After 4 days, he has given a complaint to the police because of his.
Anyhow, that we will. When once you
No,
you,
if he say
you
he's in
file
the
a
right
petition
track.
under 166, it's for you to
True, this one.
establish
That's I
that
examined the
accident has
PWT.
happened. Now, looking at the manner in which the accident has happened, while the bus is taking a right turn, you're coming from the opposite direction, and there was a head-on collision. The bus, it was a head-on collision.
Yes,
As far
ma'am.
as the driver is concerned, when he takes a right turn, he can't drive the vehicle faster.
No, my lord, not the 50%, it's a 10% observed also. In my argument is too much, but I will leave it to the court that the disturbance regarding that 10%, not
The amount granted by the court.
Pardon?
What was the amount granted by the court?
Amount granted by the court is 10,000, 10 lakh 38.
Amount 10 lakh.
10 lakh 38,000
88.
88 rupees.
88.
Page number 15.
880.
10 38088. By taking this one. And deduction is 10%. So 9 lakh 34,279, my lord.
9 lakh?
34,279.
Para 17 and 18, my lord. Even para 16 to 18.
Please come. Agreed with orders passed in MBC number 4909 of 2018 dated 28th February 2019, whereby the tribunal has awarded compensation of an amount of rupees 10,38,880 and fixing the contributory negligence at 10%. Court had granted 9,34,279. Both the insurance company as well as the claimant are before this court. The insurance company's appeal is MFA number 11, MFA number 3913 of 2019, and the appeal of the claimant is MFA number 119 of 2021. The tribunal had considered the evidence, had taken the income at 11,000.
No, 10,000 plus 1,000, this one 10%.
They had taken the income at 10,000 and future prospects at 10%.
10%.
That is 11,000 and deducted 1/3. And the salary is considered as 7,000. The contribution to the family is 7,334 into 11 into 12 into 11.
Yeah.
12 into and multiply 11 under the head of loss of dependency. An amount of rupees 9,68,088 was arrived at. Loss of consortium 40,000. Loss of love and affection 15,000. Transportation of dead body and funeral expenses 15,000. Altogether, an amount of rupees 10,38,088 was granted. Then coming to the contributory negligence, the court has fixed the contributory negligence at 10%. And the court has observed that that exhibit P3 is a rough sketch. It shows that there is a little turn where the accident occurred. BMTC bus was moving from northern side towards the southern side, but two-wheeler of the deceased was moving from southern side towards the northern side. Exhibit P3 speaks that the driver of the offending vehicle had enough scope to avoid this accident, either by taking his vehicle towards his left side or by reducing the speed of his vehicle. The accident would have not been occurred if he had taken his vehicle towards his left side. There was sufficient space towards his left side. At the same time, the deceased also had also enough scope to avoid this accident by taking his vehicle towards his left side. This accident would have not been occurred. If the deceased had taken his vehicle towards his left side, it goes to show that the offending bus as well as two-wheeler of the deceased were riding their respective vehicles in high speed and beyond their control. Therefore, the evidence of PW2 and record pertaining to the criminal case are sufficient to say that the accident occurred due to head-on collision. And looking at the facts, the driver of the bus has contributed his negligence to the extent of
50%.
90% by driving the bus in a high speed without trying to take his birds towards his left side. At the same time, the rider of the two-wheeler has also contributed his negligence to the extent of 10% by riding his two-wheeler in a high speed and in negligent manner. Therefore, the contributory negligence was fixed at 90% on the driver of the offending vehicle, 10% on the insurance company, and 10% on the deceased. Next paragraph. Land counsel appearing for the claimant submits that the accident had taken place in the year 2018, and the court had failed to take into consideration the income at rupees 12,500 and had taken the income at 10,000, which is not correct. Then coming to the deduction, when the claimants are 4 in number, court ought to have deducted 1/4, but in this case, the court had deducted 1/3. Even under the conventional heads also, the amount that is granted is not a reasonable compensation. Then coming to the contributory negligence, he submits that the evidence of PW2, the sketch and the suggestion that is put forth by the insurance company to the claimants, to the PW2, stating that as the accident had taken place at 7 o'clock, because of the headlights, the claimant may not have seen the coming bus. This strengthened the case of the claimant, there is no contributory negligence on the part of the deceased, and the court ought not to have taken ought not to have apportioned the contributory negligence at 10% on the deceased. It is submitted that on all counts, the compensation needs to be enhanced, and the contributory negligence ought not to have been fixed on the claimant, on the deceased. Next paragraph. When counsel appearing for the insurance company submits that the evidence of PW2 in fact supports the case of the in his contentions, he relied on the judgment of the apex court in National Insurance Company Limited with Birender and others, reported in 2020 11 SCC 356. Basing on that, he submits that the court ought to have considered all the 4 as dependents and ought to have deducted 1/4. Next. Land counsel for the insurance company further submits that the evidence of PW2 supports the case of the insurance company, that the accident has occurred when the bus was taking a right turn, and after the right turn he has to stop the bus at a bus stand, which clearly shows that the bus is not going in a high speed. There are the head-on collision and the IMV report clearly shows that there is negligence on the part of the there is negligence on the part of the
Deceased.
claimant, on the part of the deceased. And it is submitted that that as it is a head-on collision, the court ought to have fixed 50% contributory negligence on the deceased, and fixing 10% is not appropriate. It is submitted that all the claimants except the wife are all majors, except the wife. The others are not dependent. They are majors and they are eking out their livelihood by working as coolies. It is submitted that they cannot be termed as dependents, and if they are dependents, the claimants ought to have adduced the evidence which they have failed to do so. In these circumstances, the court ought to have deducted 50%, but not one third, and it is submitted that the compensation that is awarded by the court is on the higher side. Next part, having heard the counsels on either side, peruse the material on record. First, coming to the aspect of contributory negligence, court has considered rightly how the accident had taken place and what was the role of both the claimant, both the deceased as well as the driver of the offending vehicle. There is no dispute about the fact that while the bus was taking a right turn, the accident has happened. It was a head-on collision and the bus was damaged on the right side. This court finds some force in the argument of the counsel appearing for the insurance company that while the bus was was taking a right turn and is about to stop at the bus stand, the bus must not be going in a high speed. However, as observed by the court, to avoid the accident, he would have taken the driver of the bus could have taken to the extreme left, and also the deceased. In these circumstances, this court deems it appropriate to fix the contributory negligence at 30% on the deceased and 80% on the insurance, 70% on the insurance company. Then coming to the contribution, coming to the income, the court ought to have taken, coming to the loss of dependency, the court ought to have taken the income at 12,500, considering the accident is of the year 2018. As 10% future prospects would come to 1,250, that is 13,750. With regard to the dependency, in the light of the law laid down in Birendra, and which is subsequently reiterated with Honorable Apex Court in the latest judgment, this court is inclined to take all the four claimants as the dependents, and 1/4 has to be deducted. That is 3,437. Then his contribution to the family would be 10,312 into 12 into 11. The loss of dependency would come to 13,61,250. Then the loss of consortium, 4 into 44, 1,76,000. Funeral expenses, 36,000. In the light of the law laid down in make allowance so and so, litigation expenses 10,000. Altogether, it comes to 15,83,250. As the court has fixed the 30% contributory negligence on the claimant, on the deceased, it comes to 4,74,975. If the same is deducted, the insurance company is liable to pay 11,08,275. Still, there is 1.5 lakh enhancement.
20%, my lord, at least. Not
It's a
30%,
case. It's a
because
case. It is a
width of the
case.
road is-
It's a case where it should be taken at 50%. But
Yes,
any of court has considered
Yes.
30%.
Yes, my lord. My lord, amount in deposit may be transferred to the.
Amount in deposit shall be forth. So both the appeals of the insurance company as well as so and so is partly allowed.
Gotcha.
Amount in deposit shall be forthwith transferred. Yes, 27.
Number 27.
Where is Mr. Shivanagowda?
Passover.
Passover.
Then number 28.
28.
Number 28.
For the
Vidya.
appellate, Lords, both the appeals are of injury, my lords, arising out of the common judgment. Lords,
MFA arises of which order?
NFA 1102, lords, is arising out of MVC 79 of 2014, paragraph 11, my lord, of the judgment.
And then the next one is?
85 of 2017.
My lord, one submission, my lord, I'm sorry to interfere. May I make one submission? Regarding delay, my lord, there is no interest. There is a enormous delay of 2.5 years.
Was it Kannon?
My lord, that I have to see, my lord, in their appeal, my lord.
Look at it, if in the
Thank
earlier
you.
matter,
Please,
if the
my lord.
delay is Kannon on condition. Look at, if it is Kannon, then they are not entitled, otherwise let it be. Yes, next.
Please, my lord.
Yes.
Milords, the
Now,
appellant is.
MFA 1102, where is the table?
Milords, the table, Milords, is at page number 33, Milords. I'm sorry, Milords. Page number 27, internal page 8. Ink
18,
page 27,
18.
internal page 18. Pain and suffering 1 lakh is awarded.
1 million. 18.
18.
What is awarded is 25 lakhs.
Please, Milords.
25 lakh 65,000.
029. So under which head you are seeking for enhancement?
Milords, under the head of pain and suffering, Milords.
Let's see what are the injuries.
Please, Milords. Paragraph number 12 may kindly be taken, Milords. Apart from producing aforesaid medical documents, the petitioner has also examined Dr. Milords, got it, Milords? Imran Hussain of Gaurav Hospital as PW3. PW3 deposed that PW1 Anil was admitted to Gaurav Orthopedic Hospital with a history of road traffic accident on so and so. Upon examination, he found diffuse axonal injury, traumatic brain injury, compound depressed parietal fracture, fracture of right femur, fracture of right tibia, fracture of right humerus, and after the treatment, he was referred to Hosmet Hospital, Bangalore for further treatment. He further deposed that on 12/8/2016, the PW1 undergone tracheotomy. On 13/8/2016, he underwent treatment to the head injury. On 15/8/2016, he underwent surgery for right femur, right humerus, right tibia fracture and external fixator, and he was discharged from the hospital on 5/9/2016. Thereafter, again he was admitted to the hospital on 25/1/2017. At that time, it was diagnosed.
What do you say?
95% of disability is taken by the tribunal, considering the extent of injuries sustained. The accident being of the year 2016.
No, I'm asking you about this head of pain and suffering.
Pain and suffering, another some amount could be added, because considering the injuries, extent of injuries considered.
And the 30,000? And the 30?
Another 50,000.
Yes.
And as for the.
Then we'll come to this conveyance. How many days he was in hospital?
33 days.
33 days.
Is appropriate.
Milords, his residence, Milords, was in Kolar. He had to travel to hospital. I mean, at least his attendants, Milords, had to fly from Kolar to, which around
10,000 we will take.
80-90 kilometers, Milords.
And the 10,000?
Milords, I'll leave.
Next. Loss of future earning?
Loss of future earning, Milords. 8,000 is taken as his income. Milords, in this matter, he himself had deposed that he was earning 9,000 per month. But Milords, 8,000 is taken.
We'll take 9,000.
9,000. And considering the injuries,
Milords,
24 is 18 is a multiplier.
18 is a multiplier. That is taken correctly, Milords. I have no dispute with that.
Future prospects have to be taken.
It has to be.
Marital prospects, 1 lakh is awarded, Milords. I'll leave it.
1 minute. Let's complete one
Please,
head, then we'll go to the next one.
Is that till you to the 1,33,000?
So it comes to 11,600. No, 12,600.
25, 85, 520.
1 minute. 12,600 into 12 multiplier is?
18.
18 into 95%.
Into 95 by 100.
25, 85, 520.
It comes to 12,600 income.
Yes, no. 12,600 into 12 into 18 into 95%.
600 into 12 into 18 into 95 divided by 100. It's coming to 25 lakhs 85,520.
Please.
And then
loss of income during laid off period.
Then loss of amenities in life. That is 15,000.
That mean the loss of income during laid up, I leave it to your lordship. I don't consider.
In the case of
Another,
95%.
because 95% is taken disability, some nominal enhancement could be done.
Another 30,000?
Another 20,000.
35,000. Loss of amenities. Next, loss of earning during laid up period.
Milords, for 33 days, Milords, it is awarded.
Yes, yes.
Only for 33 days.
So 33 days he was in hospital.
He was in hospital.
They take for 6 months. So salary is 9,000.
In this case, 9,000.
Huh? It comes to 54,000.
Future medical expenses, Milords.
What is the evidence of the doctor?
Milords, doctor says that he requires surgeries which would cost around 50 to 60,000. Nothing has been awarded under that head, Milords.
What do you say?
In nominal amount of 25,000 could be.
Accident of which year 18 will grant
18.
30. Future medical expenses.
2016, not 18.
30,000. Then loss of marriage prospects not required.
That's
more
not
than that.
required
With
because
all 95%.
almost 100% is taken.
Correct. Loss of earning during loss of amenities, medical expenses, future earning, all are covered.
Yes.
Legal expenses 10,000.
ನಿಮ್ಮದ ಹೇಳ್ಬಿಡ್ತೀನಿ, ನಾನು ಹೇಳ್ತೀನಿ ನೀವು ಹೇಳೋದು.
It's coming to 36,000, 36 lakhs, 73,949 against 25 lakhs.
Yes.
65,029. Yes. Now we'll go to the next.
Connected matter.
Where is that?
It is page 23,
The
22.
table is at page 24 minutes of the judgment.
Page 24.
Please. Pain and suffering 80,000. Loss of.
No, it is not page 24 running page or the judgment
25.
page.
Judgment
20.
page. Judgment page 24.
25. That is page 24. Yes.
Lots. Pain and suffering 80,000 is awarded.
What are the injuries? Come to
Closed
that.
fracture distal third of right femur, closed fracture lateral condyle of right tibia, fracture proximal third of right humerus, closed fracture both bones of right forearm, fracture of left frontal sinus.
How many fractures?
Milords, 1, 2, 3, 4, 5, 6 fractures.
So generally we are granting one, above that 20. That's
1 lakh. 1 lakh.
Pain and suffering. Yes.
That's that. Next is loss
Then,
of future earnings.
Yes, loss of future earning. How much is considered?
9,500 is to be
Income,
taken.
Milords, has to be
What according to him, what is his earning?
25 to 30,000 he has told.
Which year is the accident?
16 Milords.
16, 9,500.
500. Yes.
And 24%
What is
disability
it?
is taken, future perspective is taken.
Has to be taken.
Yes.
What is the age?
24 years, Milords. 18 will be the multiplier.
Amenities ಹೆಚ್ಚಾಗುತ್ತಾ? ಹೆಚ್ಚಾಗುತ್ತೆ amenities.
In the earlier case, we have taken 9,000 as income because he is saying.
Restricted to 9.
In this case, it is the
Yes, yes, I
9,500.
understand. No, that's why I was looking, there is a calculation, this thing, why it has come. 13,300 into 12
into 18 into 24. 12 into 18 into 24 divided by 100.
It comes to 6,89,472. Then medical expenses as it
As
is.
per the bill, it is awarded lakhs. And loss of amenities again 15.
1 minute. 2,86,426. Loss of amenities. What do you say?
Loss of amenities, it could be enhanced by another 15,000.
Then loss of, how many days he was in hospital?
23 days, my lords. Two different spells. First time 19 days, second time 4 days, 23 days.
Period. So, we'll grant 4 months.
3 months.
3 into
9,500. 27, 28 and up.
28,500.
Conveyance, nourishment, attendance, both are brothers, my lords. Again, he was also inpatient here, and only for those days it's awarded.
what do you say in this also another 10,000? Because we have given already in the other case.
So,
Future medical expenses, my lords. In this case also, the doctor had deposed 50 to 60,000. 25,000 is awarded.
The injuries compared to the other case are less in this. Then future medical, all are covered?
No, all the aspects. All the.
Delay ittu, but then is subject to condition minor delays. $145 days is question. 145 days.
It's coming to 12,02,398 against 8,52,146. Yes, please come. Agreed with award passed in MVC 79 of 2014 and MVC 85 of 2000. It is 2017 only, not 14. MVC 79 of 2017 and MVC number 85 of 2017 dated 23rd July 2019. The claimants are before this court by filing MFA 872 of 20 and MFA 1102 of 2022 and MFA 946 of 2021. As the court below had disposed of the matter by way of a common order, this court is also disposing of these two appeals by way of a common order. First side heading, MFA 1102 of 2022. Considering the injuries that are sustained by the claimant, judgment page number 18. The court had granted compensation of an amount of rupees 25,65,029 as per the table given below. Extract the table. Learned counsel appearing for the appellant claimant submits that the claimant had sustained right parietal compound depressed fracture, diffuse axonal injury, type 3B open right femur, mid-shaft fracture, right tibia, mid-shaft fracture, type 2 open right humerus fracture, cut lacerated wound present on exterior aspect proximal fracture, with 4 into 2 into 2 centimeters with abnormal mobility. Right thigh bone exposed at fracture site measuring 3 into 1 centimeter. Deficits present. Crepitus present on the right with abnormal mobility. Range of movements painful and restricted. As per the doctor, the CT scan of the brain was done on 12/8/2016, which revealed that the right side of the brain, there is a 31 into 30 size contusion is seen in the frontal region, right-sided markedly depressed fracture of parietal bone. It is further deposed that the claimant undergone wound exploration with removal of depressed bone fragment with titanium cage cranioplasty along with debridement on 13/8/2016 and on 15/8/2016. He undergone wound debridement with external fixation of right femur and right humerus with external fixator of right tibia. Thereafter, on 5/12/2018, he examined PW. The doctor has examined PW1 for assessing the disability. The doctor has observed that he has persistent double vision and thereby he assessed the disability of 95% impairment to the body and absent nerve injury resulting in permanent double vision at 24% to the impairment to the body. And finally, he opined that he had suffered total impairment to the body at 90%, which is permanent in nature. Then counsel for the petitioner submits that with these kind of injuries that are sustained, the court has awarded an amount of rupees 1 lakh under the head of pain and suffering, which is not reasonable. Coming to the loss of future earning, court had taken 9,000. Court had taken only how much is taken?
8,000.
8,000, and court ought to have taken 9,500 as income. When it comes to the loss
9,000. In first case, 9,000. The claimed amount.
I will take it. The council submits that when the disability is 95%, under the head of loss of amenities, loss of marriage prospects, conveyance attendant charges, loss of earning during the later period, the amount that is awarded by the tribunal is not a just and reasonable compensation. Then counsel appearing for the respondent insurance company submits that the court had granted a reasonable compensation and there are no grounds to interfere with the well-considered award passed by the tribunal. Next part, having heard the counsels on either side, peruse the material on record. Considering the kind of injuries, fractures that are sustained by the claimant and also the fracture to the injury to the brain, under the head of pain and suffering, this court is inclined to grant an amount of rupees 1,50,000. He was in hospital for 33 days. Court had granted 33,000. It is submitted that he is a resident of Hassan, Kolar, and he has to travel to
Bangalore hospital.
He has to travel to Bangalore hospital, and the attendants have to travel, and as such, in addition to the 33,000, another 10,000, that is 44,000 is awarded. Coming to the loss of future earning, when it is a case with the claimant that is earning 9,000 and the accident has taken place in the year 2016, the court ought to have taken 9,000 as per the evidence, ought to have taken 9,000. He is aged about?
Because in the first case, he was 20 years.
20 years. Future prospects at 40% will come to 3,600. That is 12,600 into 12 into 18. And the court had rightly taken 95% as a disability. Hence, under the head of loss of future earning, it comes to 25,85,520. Considering the disability of 95% under the head of loss of amenities, this court is granting 35,000. Then coming to loss of earning capacity, he was in hospital for almost 4 months. Considering the same, this court is granting the loss of income for 6 months. That is 35,000. That is 54,000. Then medical expenses as awarded by the court, 6,65,429. No interference is called for. Future medical expenses, when the doctor has deposed that there is a requirement of operation, court ought to have granted the future medical expenses, and this court is granting an amount of rupees 30,000. Loss of marriage prospects, court had rightly granted 1 lakh, and this court is not interfering. In the light of the law laid down in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 36,73,949. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 25,65,029 to 36,73,949. Then coming to the next side heading, MFA 946 of 2021. The tribunal had granted the compensation as per the table given below. The judgment, page 24, extracted. When counsel appearing for the claimant submits that he had sustained six injuries and the court had granted an amount of rupees 80,000 under the head of pain and suffering. When it comes to the loss of future earning, court ought to have taken 9,500 as a income. It is submitted that for the future medical operation and under the other heads also, the court had not loss of amenities in life, loss of earning during the later period. Court had not granted a reasonable compensation. Hence, the amount needs to be enhanced. Same, there are calls for the respondent submits at a reasonable so-and-so, and no interference is called for. Next. There is the claimant had sustained as many as 6 fractures. Considering the same, this court is granting an amount of rupees 1 lakh. Coming to the loss of future earning, and as per the table for the year 2016, the amount is 9,500. He is aged about 24 years. Future prospects at 40% comes to 3,800. Then his salary is 13,300 into 12 into 18 into 24 by 100 is 6,89,472. Court had granted 2,86,426 as medical expenses basing on the evidence, and this court is not interfering. Considering the disability of 24% under the head of loss of amenities, this court is granting 30,000. Then loss of earning during the later period, considering the hospitalization for 3 months at 9,500, this court is granting 28,500. Conveyance, attendance, food and nourishment, considering the fact that he has to travel from Kolar to Bangalore, though he was there in the hospital for 23 days, this court is granting 33,000. Then future medical expenses, court had rightly granted and no interference is called for. In the light of the law laid on in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 12,02,398. Accordingly, the appeal of the claimant is partly allowed, enhancing from 8,02,146 to 12,02,398. Same, enhanced amount 6% interest. Yes, next.
Cell number 29. 29 Ashok N. Patil for appellant. 29.
My learned friend Malad requested me to seek adjournment on his behalf. His family member is not well. After 2 weeks it may be called.
This matter at the request of learned counsel appearing for the claimant. Claimant?
Yes, madam. She has also filed.
This matter on 23rd of September.
TCR will be required, madam, in this case. By that
Then
time.
we'll admit it.
Please.
Admit post for final hearing, call for the TCR. Yes, 30.
Cell number 30. Cell number 30 Lakshmi.
Appearing for petition.
For petitioner
Short date.
S. Nagaraj.
Senior inconvenient is short date. Short date may be.
Non-filing of acknowledgement for having paid the arrears of
I
maintenance.
already filed, madam.
It's filed.
Filed. So this
Awaiting mediation report dated. What is this, a mediation report?
none have appeared, madam.
None appeared.
None appeared.
At the request of learned counsel for the respondent.
I asked for restoration of the stay, madam.
Huh?
Stay after paying that amount. Stay.
No, he has cleared the arrears. Though he has cleared the arrears, stay is vacated is his case.
My lord, as on today, 10,80,000 to arrears.
This is matter at the request of learned counsel the respondent. On Saturday, let your senior come so that if he requires any restoration of the stay, we'll grant.
Yes.
Yes, next.
Cell number 31 Lakshmi Kant K for the petitioner.
Yes. Non-filing of acknowledgement for having paid amount.
Arrears, they have paid till July, my lord. Till July, they have paid arrears.
Here.
As per the orders of the honorable court.
It's only August is now.
Please.
Yes. Land counsel for the respondent submits a memo is filed on behalf of the petitioner, and land counsel for the respondent submits that the arrears are cleared till July. What is pending is for the month of August.
Yes.
When are you going to pay?
Every month we will pay
We
continuously.
are in August. 5th of August, we should be paying it.
In next month, my lord.
August, you will be paying in the month of September.
September.
The interim, this is RPFC.
Please, ma'am.
This matter on 15th of October, inter-alia granted is extended, and if the petitioner fails to pay the arrears, the stay granted by this court stands vacant.
Much, ma'am.
Yes, 32.
Till number 32. 32. Correspondent, my lord.
Where is he?
Vinod Reddy.
No representation for the petitioner. List this matter for dismissal tomorrow.
Please.
Till
Yes,
number
33.
33. Till number 33.
Balance was 55,000, my lord.
55,000,
and,
your lordship, 35,000 now.
they have paid.
Today, your lordship paid. Another, I'm already given.
Paid, my
And
lord. Just today they have.
Lordship, another
Today when the matter came up, the arrear, it is submitted that the arrears are about 55,000.
35,000 paid.
55,000 are other arrears, sir.
Yes,
And
ma'am.
out of it, 35,000 is already paid to the respondent wife. Then counsel appearing for the respondent submits that the said amount is received by the respondent. When are you going to pay the
Another
15?
My lord, one submission.
Till date, your lordship, till month of the,
Huh?
this month also including 25,000 remaining, your lordship. And 30th in the trial court, your lordship, matter is there. There I will pay 25,000.
30th of August.
Yes, your lordship.
It is submitted that the remaining amount of 15,000 will be paid.
25.
25,000.
25,
This month also include, your lordship.
this, including this month, will be paid before the trial court on 30th of August.
One
Yes.
submission, my lord. My lord, the LCR is already received by this court. If the matter can be heard.
We'll hear it. There are so many other matters which are pending much before your matter. Yes, your amounts are cleared. That is what you have to be assured now. This is matter on 14th of October.
Much.
If the amount is not paid by 30th of August, the respondent is at liberty to move this court, and on that day, the court will vacate the interim order.
Please, please, your lordship.
Yes. Interim order earlier granted is extended. Yes, next.
34 urgent. 35. Arun Govind Raj for petitioner. Tututar.
Krishna. My lord, in this case, 19/3/2024 in your order, may I read that, if you permit me?
What was earlier?
It is given that the
4/8/2025, land counsel of the petitioner submits and the land counsel respondent has come up with voluminous memo and he requires a
Yes.
time to respond to the same.
we are given our objection for that. So my lord, I'm reading that 19/3/2024 order, the line number, the last, I'm reading that. The respondent wife should come up with the requirement respective leaves peacefully. In view of the same, the respondent wife shall come up with the memo or with an affidavit before this court. What are the terms of compromise for her, and this matter will be listed on that. So there are, post which they are given one memo of settlement agreement. So if the other side permit, my lord, we can refer the case for the mediation.
Lord,
and
we
can
have
take it
already
forward for
tried
that,
twice, my lord, pursuant to a direction of this court. Twice mediation was tried, that failed. Your
Appear
lordship,
before the senior counsel, Sushila. So going to the mediation center.
we can, my lord, I have no objection.
What
but
we do is,
yes.
we'll fix a short time.
Yes,
Because this is a case.
yes,
where
yes,
you have
I'm
to
not, I have
settle
no
it.
objection.
The parties shall, Mrs. Sushila, senior counsel, is appointed as a mediator, and parties shall appear before her on
Post Vinayaka Chaturthi, my lord.
on 2nd of September.
Third with
2nd of September.
second, I have more matters.
When-
Third maybe.
Yes, 3rd of September.
Much.
Yes, please.
Obliged.
Cell number 36. Prasanna VR for petitioner. Jagan Mohan.
No counsel for the respondent is present. No representation for the petitioner. List this matter for dismissal tomorrow.
Cell number 37. 37.
Counsel for petitioner. Earlier is directed to respondent advocate to clarify the settlement of the
Nita Singh Correspondent.
Permanent alimony.
Huh?
Directed to the respondent advocate, permanent alimony. Rupees 9,75,000. Clarification.
Land counsel for the petitioner submitted the respondent have taken permanent alimony of rupees so and so, same was transferred to a record. Is suppressed in a statement of the answer. Land counsel has time to get instruction. Though counsel for the petition is present, no representation for the respondent. List this matter on September 9th. On the day, even again, if the respondent is not present, the basing on the submissions made by the counsel for the petitioner, appropriate orders will be passed.
Kindly extend the interim order.
The order earlier granted is extended.
Much
Yes,
obliged.
next.
38, Akash.
I'm for the petition in the first part. I'm ready.
Your Lordship, kindly grant the Passover. Senior is not there. She's held up in arbitration.
Passover.
Much.
Yes, next.
Yes, Mr. Last occasion, respondent filed the memo for calculation.
39 then.
Total amount 67,000 million. I paid the today. I paid the 60,000 amount.
How much?
60,000.
Land counsel for the petitioner submits that today he has paid 60,000 and the outstanding is
Outstanding 1 month. This month.
only this month is the outstanding. No representation for the respondent. List this matter on 11th of September.
Interim order.
Interim order earlier granted is extended. Yes, next 41.
PL number 41. 41. Amal Korea.
Passover. Passover.
Passover. Yes, 42.
PL number 42.
My lord, serial number 42, I appear for the petitioner, my lord. My lord, there is a transfer petition pending before the Supreme Court with respect to this writ petition and the main MC matter, my lord. The MC matter has been stayed and this writ petition has also been tagged along with the transfer petition, my lord.
I am for the respondent in this connected matter, please. I have not filed power for the respondent in this first matter. I will do that.
With the land counsel appearing for the petitioner that the MC proceedings were stayed by the Honorable Apex Court. He has sought for the transfer and this writ petition is also tagged on along with the transfer petition. List this matter on 15th of October.
CP number eligible.
Yes.
CP number.
CP number 99 of 2025 and 11 of 2025.
Yes.
43 urgent. 44. PL number 44. MJ Alva.
I'm appearing for the respondents.
SR Ravi Prakash.
Yes.
Husband's petition against the grant of interim maintenance.
Where is the order?
Annexure A may kindly be looked at page 11.
The maintenance of 20,000.
Please, my lord.
Both husband is before the court.
Husband is not before.
No, I'm saying petition.
Husband is before the court. Please.
Yes. So what
Both
is
are
the,
engineering
what is the income
graduates.
of the husband? Income of the husband.
Income, he is getting some 75,000 rupees.
No. 1 lakh.
1 lakh. All right.
1 lakh
Even if
8,000.
it is 1 lakh, my lord.
And what is the income of the wife?
Wife is not working.
She is an engineering graduate. She has been working in a company.
They
She has been
alleged
earning
that
75,000 rupees rent. She has got agriculture income also.
No. Where is the statement of assets and liabilities?
My lord, wife's statement of liability, your lordship will find it at annexure H, page 56. Kindly turn to page 59. Your lordship will find, apart from her personal income, she has got agriculture income also.
Where do you get that?
Page 59, G, assets,
Column number?
column number 9, G, assets, agricultural land to an extent of 3 acres 7 guntas, situated so and so, standing in the name of the deponent. Deponent is the wife.
And what about her income?
My lord, so far as her income is concerned, my lord, she has been working, my lord. This is the.
So what did she say so in the statement?
Now she says she is not employed.
No, before the trial court.
Before the trial court, she says she doesn't have income. That's what she says.
Approximate expenses incurred on account of the dependent is 40,000.
The application, your lordship will find it at annexure F.
So according to her,
Page
she's
42.
unemployed. She's unemployed and she's having that land.
He now says she is unemployed.
That's why I'm
But
asking.
your lordship may kindly consider, at the time of marriage, she has admitted that she was
But
working.
Not at the time
Now-
of marriage.
Now, I,
No.
in fact, have relied upon the judgment of
No,
the
no,
Supreme
not the
Court.
judgment. I want you to show,
Please.
as per the statement of assets and liabilities, whether she's working.
As per the statement of assets and liabilities, she has stated that she is not working.
She's not working.
But she is qualified. She is an engineering graduate. She is capable of earning. She has admitted about her
So when is the date
qualification.
of marriage?
No, the date of marriage is 28/8/2020. Got separated on 15/9/2020 within 18 days. 15/9/2020.
Why she's not working?
No, all the facts, let him complete. I will.
No. This fact needs to be clarified.
She has resigned from the job because it was insisted by the husband that she shall not work so to get married.
When she resigned?
She resigned. Her resignation was actually there. No? My lord, before that, of course, since your lordship asked it, I will produce it. It's a copy, Xerox copy. She resigned on 17th September 2018.
How can she, marriage is on 25/8/2020?
I'm sorry. Yes. 2020. Marriage was 2020.
25/8/2020.
No, one minute. ಇದಲ್ಲ? ಇದು 20th February, I'm sorry, 20th February 2020.
How can it be? 20th February 2020. Your marriage is on 25/8/2020.
28,
Then
8,
within
2000.
15 days separated.
That is
After
their
that,
claim. It's not separated. I have proof. Let him claim it. Yes, it is not within that. Marriage was happened on 2020 and she separated on much later, after in the year 2022.
who filed the MC?
MC
Husband filed the MC.
In there, I will quote it from the record itself. Kindly
No,
see
you must, you must have filed your objections to the MC.
Yes.
In that, according to you, till what time both of you are residing together?
They were rival. Even at the time of filing the suit for divorce, they are living in the same house, in the same address. Kindly see annexure B. Annexure B, their petition, MC number 2540. Husband and wife's address are the same. Date of separation. Yeah.
So at least from 2022 till now, what is she doing?
She's separated. She's living with her husband in her auntie's house. She has lost her husband, father. She has no father, only mother.
Why is she not working?
She is not working.
Why?
She could not get the job.
What are the efforts made by her to get a job?
That I have to say.
You please file an affidavit to that regard.
Yes.
Then counsel appearing for the petitioner submits that as on the date of the marriage, the wife is working. She's a double graduate.
Yes.
No,
She's graduate, engineering graduate.
Graduate. She's an engineering graduate. According to the learned counsel for the respondent, at the insistence of the husband and the in-laws, she has quit the job. And in spite of her best efforts, she could not secure a job. The respondent shall file an affidavit before this court. After they have separated, what are the efforts made by her to secure a job? When do you want?
Next week. Next week, my lord.
Huh?
Next Monday.
This is matter on 2nd of September. Yes, next.
Number 45, Fatima escape.
Interim order may kindly be
The order earlier granted is extended. Yes, 45. Yes, pass over.
Sale number
Yes, next.
46 urgent, sale number 47,
47 is adjourned.
48,
Yes.
sale number 48, Ravi Shankar Shastri.
Where is Mr. Shastri?
DC Shivanand.
Password? It's 49.
Sale number 49.
49, Your Lordship. respondent one, still filed by the claimant, owner is dead. And
Liability is on whom?
liability fixed on the owner only and dispensed with the owner. How can it?
Let's see all, the password. Yes, next 50.
Jail number 50. 50 and Krishna Swami.
Bring for the respondent.
No representation for the appellant. List this matter for dismissal tomorrow.
Jail
Yes,
number
51.
51.
No representation for the appellant. List this matter for dismissal tomorrow.
Jail number 52.
Adjourn.
Urgent 53. Jail number 53.
No representation for dismissal day after.
Jail number 54. 54 Pradeep B.
Passover.
Jail number 55. 55 Vishwanath Reddy.
No representation for the appellant. List this matter for dismissal on 9th of September. Yes, next.
Jail number 56.
I am for appellate in this case, madam.
Syed Abdul.
Who appear for the respondent? Pradeep. Ready? Yes. Give the file.
7/8/22 is the date of accident.
7/8 is a date of? It's a death or accident?
Injury.
Injury.
He was
Come to
admitted in the
the,
hospital.
come to the table. What are the injuries sustained by him?
Para 29.
Please tell the court.
Right knee depressed fracture of medial tibial plateau with condyle lamellus with a fracture of fragment with the right knee fracture.
How many fractures?
2 fracture. Doctor has assessed the disability to the limb disability at 38%.
38%?
8%.
To the limb. The whole body it would be?
That means, Millard, 38 means 12% it is.
13%.
Not 14%.
12%, it comes to 13%.
Please. But court has taken 5%.
So as far as pain and suffering, 2 fractures, 60,000 is appropriate, Mr. Abdul Sabur.
My lord, it should be little more, my lord.
No?
70,000.
Amenity we need to pay.
Yes, next. Loss of amenities, we can increase.
Another 10.
Another 15,000.
Please.
Next, medical expenses.
As it is, it is. 6 days he was in the hospital.
70,319. Loss of earning during later period. How many days was in hospital?
6 days.
6 days.
What, which year is the accident?
22, Malak.
What is the amount?
15,500.
15,500.
Please.
Into
It is
3.
taken.
Into 3. Into 3, it comes to 46,500. Then attendant, how many days he was there?
6
6 days. 5,000 has been awarded.
Another 1,000.
That's all.
Next.
Later period.
Loss of future earning. How much was taken?
15,500 taken.
Is taken. So
15,500
15,500 into 12 into
17 multiplier.
17 is a multiplier into 13 divided by 100. It comes to 4,11,060. Then any other future operation?
Future medical has not been provided.
No evidence.
No evidence.
No evidence. According
Doctor said
to
it is required. Doctor said it is required future operation for removal of implants.
Yes, implant.
No implant, Millard.
No implant.
No implant.
Yeah, implant has been.
Huh?
Implant has been inserted, my lord.
Partial, no,
Look at it.
no, my lord. Para 29 may kindly be seen, my lord. It is
20?
external, ಇದನ್ನ ಇದ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. They have not operated. Look this arthroscopy of ACP.
Surgery on
ACL
12/8/2022.
tear ಆಗಿರೋದಕ್ಕೆ ಇದ್ ಮಾಡಿರೋದು ಅಷ್ಟೇ. Not undergone any implant, any tissues are not available in that. Therefore, he is not entitled to get trouble. His muscles was tear, therefore that was stitched.
So, what legal expenses? It's coming to 6,43,879
Yes, ma'am.
against 4,02,659.
Please.
Please come.
Negligence 2080 it is.
Where is that? What do you say on this composite and the contributory negligence?
He himself is the tortfeasor court has observed by.
Any submission on that?
My lord, it should be reduced to.
Just like that, why it should be reduced into 20 divided by 100. That is 1,28,775 minus. It comes to 5,15,103.
Much.
Agreed with the order passed in, award passed in MVC number 12912 of 2022. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 39 lakhs for the injuries sustained by the claimant in the road traffic accident. The tribunal has awarded the compensation as per the table given below. Then counsel appearing for the petitioner submits that under the head of pain and suffering, the amount that is awarded by the tribunal and under the head of pain and suffering, loss of amenities and loss of earning and the attendant and nourishment, and under the head of loss of future earnings, the amount that is awarded by the court is not just and reasonable. It is submitted that as per the doctor's evidence, 38% is a disability to the limb, and the court had taken 5% instead of 13%. It is submitted that the contributory negligence that is fixed on the claimant is without any basis, and the same needs to be reduced. And there is no contributory negligence on the part of the claimant. When counsel appearing for the insurance company submits that based on evidence, court had fixed the contributory negligence at 20%, and there are no grounds to interfere. It is submitted that on all other grounds, the compensation that is awarded by the tribunal is just and reasonable. Next para. The claimant had sustained, where do you get the injury?
Para 20. Para 25 issue number.
25.
Exhibit P5, which wound certificate shows the petitioner fracture.
The claimant has sustained fracture of medical tibial plateau and intercondylis eminence, with fracture of fragment within knee point, fracture of tip of proximal fibula, complete anterior and posterior cruciate ligament tear, bucket handle tear of medial and lateral meniscus. That is medial or medical?
Medial.
Medial lateral meniscus. The court had granted an amount of rupees 60,000 and the head of pain and suffering. Considering the injuries, this court is granting 70,000. Coming to loss of amenities of 13% of disability, this court is granting 30,000. Then coming to the medical expenses, court has rightly granted an amount of rupees 70,319 basing on evidence. Then coming to the loss of earning during the later period, considering the injuries, this court is granting for 3 months 15,500 into 3, 46,500. Attendant food and nourishment, he was there in the hospital for 6 days. This court is granting 6,000. Then coming to the loss of future earning, when the doctor has opined that it is 38% disability to the limb, court ought to have taken 1/3 of it, that is 13%, but the court had taken in 5% without any basis. And this court is taking the disability at 13%. 15,500 into 12 into 17 into 13 by 100 is 4,11,060. In the light of the law laid down in make allowance so and so legal expenses 10,000. Altogether, it comes to 6,43,879. The court had given a finding with regard to the contributory negligence, fixing 20% on the claimant. This court has perused the order, and the court had rightly fixed the contributory negligence at 20%, and this court finds no reasons to interfere. The 20% of the contributory negligence would come to 1,28,575. Hence, the insurance company is liable to pay an amount of rupees 5,15,103. Accordingly, the appeal of the claimant is partly allowed. Enhanced amount shall carry 58% interest. Is next.
Cell number 57, Ramesh KR.
Appealing for the appellant in this matter. Claim.
Loss of dependency is under dispute.
Keep this. What is that?
Loss of dependency.
Loss of dependency. The income of the deceased, my lord, the trial court was taken.
Where is the table?
My lord, table, my lord, in page number 23. My lord, produce the salary certificate before the trial court, my lord, exhibit P14 and exhibit P13.
Whom you have examined?
My lord,
Not examined.
he is a permanent employee. My lord, they have one document per a moment, my lord, kindly say.
Not examined.
No, but still you need to examine.
But my reason is this, my lord. The document produced by the trial.
If you want, I can remand the matter for reducing the evidence. But I can't consider that without examining the concern. If not, then we have to take the.
My lord, the notional income is more 40,000.
Then better we will remand this matter. You reduce the evidence.
Please.
Without reducing the evidence, we cannot consider.
My lord, I will take instruction, my lord, and that.
List this matter day after tomorrow at the request of learned counsel.
Before the my lord, local matter was settled, but
we agreed for 12,30,000 rupees in addition.
But they have instead, my lord, they want court
They also
order.
insisted the same.
Court order.
Who insisted client?
Insurance company officials, my head office, they insisted the same.
Court order.
The court order.
No, ma'am. Employer's evidence.
Get instruction.
Please.
Day after tomorrow at the request of learned counsel, the appellant.
Cell number
Case
58. Nanjunda Swami N for appellant. Petitioner.
Appearing for the respondent in this matter, my lords. My lords are directed us to see if there is any settlement in this matter. So we approached them asking to give us any amount. Instead, they filed a memo, my lords. I'm filing my objections to that memo, my lords. Kindly pass her.
List this matter
My lords.
on 3rd of September. Yes, next.
Cell number 50.
Madam, my lords, my objections to memo.
File in the section.
Please.
Yes, next.
59. TN Vishwanath.
59 Mellad.
Ramesh.
I represent VR Datar Mellad.
Two connected matters, my
not-
lords. In one, I'm for the petitioner, in one, respondent, 1 and 2.
Datar sir is not in station Mellad. On the last occasion also I requested. Another 4 weeks may kindly.
No
be
4
granted.
weeks. List this matter on 10th of September. No further adjournment will be granted and the council shall, the council appearing for the daughters.
Until
Shall
16th
proceed.
Mellad.
Huh?
16th.
16th.
Please. Please.
Cell number
Yes.
60.
Much.
Cell number 60. Yamali Ramatkar.
No representation. List this matter on 11th of November.
Cell number 61.
I'm for the petitioner in this case, my lords.
Pray for time, kindly have tomorrow.
Rajaram.
Why 24 matter, already respondents are served, we're here the matter. Any stay in this, look at it?
No. It was not filed vocal custody.
No, not filed. But then what is the purpose of keeping this matter pending here? MCs of which year? Give it. This is the file. There is impugned order.
So kindly, tomorrow, my lord. Inconvenience.
IA number 8 filed by the respondent is hereby allowed. Office is directed to return the petition to the next friend of the minor petitioner. Presentation of the same before the Chambers of the Court, which has jurisdiction. Why are we keeping it pending from 24? You are the arguing counsel or somebody else?
Counsel.
Where is the counsel?
Rajaram.
Feeling not well.
List this matter on Saturday. No further adjournment.
Tomorrow, my lord.
Tomorrow.
Please.
No further adjournment. Yes, next.
List number 2.
Dismissal matters call in the afternoon.
Yes, ma'am.
All dismissal matters in the afternoon.
For the orders matter, serial number 4. Narendra Gowda. List number 2, serial number 4.
Steps to be taken in respect of R1 since postal share refused. Notice to respondent R1 A and B refuse of the postal share refused amounts to deemed service of notice. Next, where is Pradeep? IA number 1 of 2025 is filed to condone the delay of 1,150 days. In filing the LR application. IA number 2 of 25 is filed for setting aside the abetment, and IA number 1 of 22 is filed to bring the LRs of the deceased R1 on record. Considering the reasons stated, the delay of 1,150 days is condoned. IA number 1 of 25 is allowed, and consequently, IA number 2 of 25 is allowed by setting aside the abetment, and the LR so and so are taken as LRs of the deceased R1. Yes. Yes. Admit post for final hearing. Call for the CCR.
Serial number 5.
Serial number 5 appear for the respondent, my lord. In this case, I filed an IA, my lord, to withdraw the award deposited amount before the trial court. Because, my lord, the
respondent has filed IA number 1 of 25, seeking withdrawal of the amount, no representation for the counsel for the appellant. List this matter tomorrow. If tomorrow there is no representation, IA number 1 will be allowed. Yes, next.
Serial number
Obliged.
matter 6 urgent. Serial number 7. Serial number 7. YV Ravi.
Respondent number 1 and 2.
Respondent number 4, my lords, I appeal.
Pass over. Next 8.
Serial number 8. Serial number 8. Manjunath ND.
Pass over.
Serial number 9. Shantaraj K.
I appear for the appellant in the connected matter, my lords. Quantum and negligence is challenged.
Where is he? Where is Mr. Shantaraj? Pass over. Yes, next.
Number 10. Final hearing, serial number 10. Raja Subramanya Bhatt B.
You are ready?
I'm ready.
Pass over.
Yes. In this, Lord, I can start with, but I need some 1 week time in this because I don't have
the
the
request of Land Council for that on 23rd of September.
This is a
Yes.
Serial number 11.
Pass over.
Serial number 11. Pass over. 12.
I appear for the appellant, my lord.
Yes, pass over.
Day after tomorrow, my lord.
When you day after tomorrow again, how many times it has to be adjourned?
Unfortunately, my lord, age factor, I'm really suffering, my lord. I am sorry, I understand, my lord. In fact, I am ready. Judgments all tagondidini, but today,
no further adjournment
because of the weather, my lord, I am.
Yes, next.
Serial number 13.
Grateful.
HJ Ananda. 13. HJ Ananda.
Pass over.
Serial number 14. Vijay Kumar T.
Pass over.
Pass over.
Serial number 15.
Please, pass.
Pasor,
Cell number 16,
Pasor.
Chandrasekhar. Cell number 17,
Appear for the appellant, my lord.
Swami.
Ready?
Yes. Yes, come in the afternoon.
Cell
Yes.
number 18.
Will, remaining matters will call in the afternoon. Yes. Take. Any signatures?
Court officer, madam. Hello. Court officer, madam. Madam, list 2. One ನಿಮಿಷ madam. List 2, serial number 12 ಏನಾಯ್ತು madam? ಹೌದು ಮೇಡಮ್, ಗೋಪಾಲ್ ಕೃಷ್ಣ ಆಫೀಸ್ ಮೇಡಮ್. ಯಾವತ್ತಿಗೆ ಮೇಡಮ್? ಓಕೆ, ಡೇಟ್ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಮೇಡಮ್, ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ
9th.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಮೇಡಮ್, ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ
ಪಾಸ್ ಓವರ್ ಅಲ್ಲಿ ಇದೆಯಲ್ವಾ? ಇದೊಂದ್ ಜೊತೆ ಇನ್ನೊಂದು ಇದೆಯಾ? ಹಾಕಿಸ್ಕೊಳ್ಳಿ ಹೆಂಗಂದ್ರೆ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬಂದಿರುತ್ತೆ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಮೇಡಮ್.
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಇದೆ ಸರ್, ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಅದರೊಳಗಡೆ 2-3 ಮ್ಯಾಟರ್ ಅಷ್ಟೇ ಅರ್ಜೆಂಟ್ ಆಗಿರೋದು. ಇದೆಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಗೆ ಇದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 5, 6, 10, 4
ಮೇಡಮ್ ಮೆನ್ಷನ್ ಮಾಡಬಹುದಲ್ಲ ಮೇಡಮ್ 230
ಅಷ್ಟೇ ಮ್ಯಾಟರ್ ಅರ್ಜೆಂಟ್ ಆಗಿರೋದು. ಅಂಡ್ ಸೀರಿಯಲ್ ನಂಬರ್ 20.
ಓಕೆ ಓಕೆ.
ಯಾವ ಡೇಟ್ ಮ್ಯಾಟ್ರು ಬಂದಿರ್ಬೇಕು, ಈಗ ಸೈನ್ ಮಾಡ್ತೀನಿ.
ಅದೇನ್ ಡೇಟ್ ಅಲ್ಲ ಮೇಡಮ್, ಬಟ್ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲ ಸೈನ್ ಆಗಿಲ್ಲ.
ಸೈನ್ ಮಾಡಿಸ್ಬಿಡಿ. ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಆಮೇಲೆ ಕೊಟ್ಟರು ಅವರು. ಈಗ ಹೋಗುವಾಗ
ಕೊಟ್ಬಿಡಕ್ಕೆ ಈಗ ಸೈನ್ ಮಾಡಿಸ್ಬಿಡ್ತಿದ್ದೆ. ಮತ್ತೆ ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಮಾಡಿಸ್ಕೊಂತೀನಿ, ನಮ್ಮ ಕೈ ಕಳಿಸ್ಕೊಬೋದಾಗಿತ್ತು.
Manoj, may make a mention, Manoj.
What mentioned now?
Manoj, serial list to serial number 7, Manoj. It's passed
No
over.
mentioning, no mentionings. Now please wait for your turn. Please call the list, call the pass force.
Pass over matter, list number 1, serial number
May I
9.
make a request, my lord? Serial number 55 in list 1, my lord. Your lordships have adjourned it to 9th of September. I would request for 10th of September.
Yes, next.
Please.
10th.
Pass
Serial
over.
number 9.
They have not served a appeal memo in order to know what is the case fact.
Because nobody is here. Take the court file. Give him the court file. So that you can assist the court. We'll call it next.
This is unit in name.
No, you are the.
Memo is given, my lord, it is very difficult for me to address the argument. That's the problem. But,
Oh, extra copy would be there.
if it is given,
The registrar is directed to give a copy of the MF appeal memo, appeal to the counsel for the respondent insurance company. List this matter on 11th of September. Yes, next.
Serial number 27.
in this case, challenging the liability, claimant has prepared one appeal. It is posted along with that. Claimant has filed another cross appeal that was not put up.
In the light of this appeal, that has to go.
Correct, my lord. In the after service of notice, how the second cross appeal was filed by the claimant is the question. Liability is under challenge, my lord.
What we do is, we'll decide this.
Put up that, my lord.
You're ready? If you're ready, problem is again posting the matters. Like there are tomorrow itself there are about 80 or 90 date given matters. That's why I'm very cautious in adjourning the matter.
Please.
So if you're ready, you please argue this matter. We'll decide it. The cross objections we'll have it and tomorrow and we'll dismiss it.
No problem. In this case, what has happened? We have adduced the evidence. We have not adduced the evidence before the MSCT. After the judgment was passed, we came to know, my lord, the driver was not having a driving license, which is a fake one. We obtained the DL certificate. We filed a miscellaneous petition before the MSCT, contending that this is the fake one. The MSCT has dismissed my miscellaneous petition, stating that it's an appealable case. That's all the case. Pay and recovery has to be passed.
Where are the documents pertaining to that?
That is in miscellaneous petition. If Disamba court permit me, my lord, I will produce the document before.
List along with so and so number.
134 up 24.
130.
Give the number. Admit, call for the TCR. List this matter on. TCR is there. List this matter on 23rd of September.
Macho.
Serial number 38. 38 serial number.
One of the petition, I am the petitioner, my lord.
I have challenged the interim order with regarding the maintenance, my lord, wherein the lower court has ordered for an amount of.
There is that where I've asked you to file a memo with regard to the expenditure of the wife. Where is that?
Yes, ma'am.
On 17/9/2024, I have filed.
When was it filed? Date of the memo.
On 9/9/2024, my lord.
Nine.
2024.
When is the order passed by me directing you to file the
The immediately prior a week before.
Date, what is the date of the order? Affidavit to post these matters on 9/9/2024, and by the time affidavit shall be placed on record.
I filed on that day.
That is on, this is 9/9/2024.
My lord, I think it is on 28/2024, my lord. A detailed order has been passed.
Yes, I've seen that. So let's see, what is the affidavit?
My lord, with regarding food expenses at the residence to meet for the expenses of the petitioner, my lord, with regarding.
What she would eat for 40,000 in a month? To prepare the, I think, like all opportunities that are given to the wife. Now, she is residing in the house.
Yes, my lord. But the
Everything
food-
is available.
No, my lord, the food is not available to me.
No,
Even
this
I
is-
have no access to feed my kids also. But he is providing food to kids when he is with them. Otherwise, my condition is worse than the servant. I have to beg for each and every aspects.
If that is the situation, you wouldn't have been staying in that house from the last several
My lord,
years.
where I will go, I have spent around 24 years of married life with that person. Earlier, my lord, I was one submission, my lord, one submission to the court.
You
Hello,
please tell the other requirements. 40,000 for food expenses. Next, cloth, dress. That is 30,000 per month. Next, medical expenses, where I'm suffering with knee joint pain, need to take regular medication, physiotherapy, I'm suffering 41,000. Next, daily needed women accessories. When is this filed? Even after the order is passed?
After the order, my lord.
Earlier, I had filed an affidavit with
For 5 lakhs.
of 6 lakhs, my lord. And my lord, upon the order of the Honorable Court, my lord, I have filed for 2,40,000, my lord.
She's living jointly.
My lord, my lord, the important aspects, my lord, earlier I was working as a manager in HSBC Bank. And after my marriage, I have been forced to leave my job. And since then, I'm supporting my husband. At that time, my husband was an ordinary man. And within a span of 20 years, he has grown to certain extent. My lord, my contribution is there. I sacrificed my job. My lord, I have sacrificed my entire life because of his upliftment. And today he has reached to this stage, my lord, he is worth of more than 150 crores today. My lord, today I am suffering for my daily needs. My lord, my bank statement can be seen wherein she showed that I have received frequent deposits. My lord, it is borrowed from my father, it is borrowed from my mother, brother, and gold loans. Every possible way I'm raising loans. My lord, I'm paying the interest regularly. I'm managing from money from here to there to here. My lord, though I'm living in a posh bungalow, my condition, sometimes I should take the help from the servant of my house. No doubt, my lord, I'm an MBA graduate, but it's been 20 years. It's been more than 20 years that I have left the job because of the husband. And today, I have put all my hard work for his upliftment of his company, my lord, without taking a single pay as a salary. My lord, he roams in a Mercedes Benz. Today, he has come to the court in Mercedes Benz. I have come in a BMTC bus. My lord, I have my own personal dignity, my lord.
Where is that involved? Where is that expenditure?
My lord,
You forgot to mention that.
No, I mentioned with regarding traveling allowances.
Where is that? I think you have forgotten that.
No, my lord, I mentioned.
He has come in a Mercedes Benz which is 12 years old. She's living in a penthouse.
That is missed out.
No, my lord, in the general expense I have included.
Where is that? Yes. What do you say?
I filed an affidavit where I demonstrated
Is that?
65 lakh rupees. That is on 5th September 2024, my lord.
Date.
5th September 2024, my lord. I filed it on the same day. It's with a bunch of documents, my lord.
Reduce the speed of both the funds. Reduce it.
My lord, wherein he has placed some LIC policy which is standing in my name. My lord, nominee is he.
Application is
LIC
mine. Let me submit.
No, I'm submitting.
The lordship has asked me, I'm
My lord,
explaining.
wherein it is nowhere going to help him because in the event something goes to.
Then you can give her, you can
Reply
respond
once
to-
I submit.
Where is that?
Please.
Oh.
Your lordship may kindly see the affidavit. filed.
5/9/2024.
Yes, ma'am. Your lordship may kindly see page number 7. I given each and every detail of the amount transaction happening in her account. She also has a demat account. Who has demat account? They have shares in circulation. This is total 65 lakhs total amount. The transactions what I have given, page wise I have given in their assets and liabilities filed by them only. Other than this, your lordship may kindly see page document number 1, page 4. Your lordship may kindly see this is a family insurance which he has done. Star Health Insurance. In this entire family members, your lordship may kindly see the page 12. Her insurance is also there. She can take any amount of insurance claim can be done. This is a family insurance. Your lordship may kindly see the next page. After the insurance, your lordship may kindly come to document number 2. In this, the details has been shared by to the wife regarding the Star Health Insurance. He has stated whatever you want, you can claim. Your lordship may kindly see to page document number 3. This is also LIC policy which has been taken in the name of the petitioner, my lord. And your lordship may kindly see the premium paid and everything is taken care. And document number 4, where she said that he's not taking her anywhere. Malaysia trip, other trips, Dubai trip, all this economy class, whatever he has gone, he has taken her and gone. Travel agency, page 27, where the details of her name is reflecting. Then your lordship may kindly see page 28, document number 5. The child has been admitted in this educational institution, my lord. The husband has bearing the entire expenses of this. The next page of that is also pertaining to the tuition fee paid for the child. And the next page, page 30, also reflects all the payments done. And so far as my lord, the company is concerned, which he was once upon a time a builder. Document number 6, if your lordship may kindly see, the company is wound up long back. This is page 32, document number 6, my lord. Order of cancellation of registration. That is his company. Got cancelled long back, my lord. And the next page, your lordship will see the registration is also cancelled. Registration certificate of Skion projects, that's also cancelled. The company is also wound up. Then the income tax returns has been filed. Your lordship may kindly see the page 42. There is one club also, Indian Gymkhana Club, where also she's have a smart card. She can use the club also. Page 42, my lord. Page 43, her name with the identity card I have produced. Other than this, my lord, they are living in a penthouse. There is a cook, there is a servant, and she decides what is to be cooked. In fact, he's diabetic, he's BP. He's not allowed to even direct the cook that cook this for me. She will make a big menace, fight with the children, so he doesn't take the food at all at home. This is his condition. She has stopped living with him like husband wife for the past 15 years. And still he's maintaining each and everything. Your lordship may kindly see the trial court order. Even the honorable court has recorded. Everything is taken care. Still, let her have some money. So they give. I read that particular paragraph, my lord. How the court has come to a conclusion. I'll just read that paragraph. The order of the trial court, my lord. The reasoning, I'll just come from the reasoning. Only few paragraphs I'll highlight before your lordship, my lord. The reasoning starts at internal page 37, my lord. Point number 12. May I, my lord?
1 minute.
No, it's, your page will be different. Sorry. This is petition. Point number 12, page 13. Hold this. Nine, okay. It should be 22 onwards.
Come to para 16 of his,
Of the
the IA
judge.
that is filed, it's not IA, it's affidavit 17/9/2024.
Same.
In that IA, come to page 16.
IA filed on 17/9.
17.
Affidavit is filed on 17/9. In that affidavit, come to page 16.
79, yes, my lord. In that page 16, my lord. Yes, ma'am.
What is that?
All this money, whichever he is stated he is borrowed, all this for investing in the shares.
Look at it. She says.
Yes, I'll explain this, my lord. From the mother, availed a gold loan from brother, sister-in-law, or there is no proof to all these things. It is only our statement. Even going by the statement, All this money is nothing but her own money she's putting on share market and rotating it, which is to the tune of 65 lakhs. And there is also one land, your lordship may kindly see, from mother BSNL side. This is not from the mother. Entry itself is there that it has gone from her account and she has bought a BSNL land. That was also one of the contentions I've taken, that she bought a site. If she doesn't have a money to eat, from where she will buy the site? The site, the money has gone from SBI, her account. I can show that entry also, my lord. It's not taken from the mother. It has gone from her SBI account where she is rotating her share. The details which are given in an affidavit, I can even demonstrate one by one, all the money which is circulating in the share market. And every day there is a transaction of 10,000, 15,000 in our assets and liabilities itself, my lord. I have given, if your lordship may kindly see the detailed chart I have provided, the end of the amount, 65 lakhs is the total rotation amount. And this I have given page wise, my lord, of her assets and liabilities. In the affidavit, what I have filed, I given the date, the money transaction of so many lakhs on so and so page of her own assets and liabilities. Your lordship directed me to file an affidavit, which I stated on that day, that she has a circulation of 65 lakhs in the share market. Your lordship wanted me to file in a form and affidavit. I filed in form and affidavit. I can now take your lordship to the assets and liabilities of her bank statements, where she's circulating everyday basis. I will demonstrate, my lord. Her own assets and liabilities, I will take it and show it to your lordship. My lord?
Come to the impugned order.
Impugned order. Yes, my lord. Before we proceed on the reasonings, my lord, if your lordship may kindly see the paragraph 8, my lord. Paragraph 8 of the order. I'll just read one para and I'll proceed to the reasons, my lord. May I, my lord? It is also contended by the petitioner. Petitioner in this case is me, my lord. The respondent has borrowed 31 lakhs 25,000 from the petitioner as a hand loan and gave it to her brother, saying that it would return by 1 year, but the same has not been returned. Respondent has invested on shares and created huge loans to the petitioner. Respondent is going through the health issues and she is under treatment from the date of marriage. Petitioner has consulted several doctors to cure her health issues of the respondent, and all went in vain, as the respondent was not taking the prescribed medicines and also not following the instructions of the doctor. All such medical expenses are borne by the petitioner. Now I'll come to the reasoning, my lord. Yes. Reasoning starts at para 12, my lord.
Yes. Yes.
I'll read, my lord. Para 14, it gives the description which your lordship may kindly permit me to read, my lord. As per the particulars disclosed in the disclosure affidavit of the petitioner, his monthly general expenses is 1,50,000, whereby his daughter's fee is 2,65,000, daughter's tuition fee is 60,000, school transportation is 22,000, and son's sports fee is 1,20,000, and son's sports fee is 3,16,000, school transportation 12,000, wife's life insurance 30,000, daughter's life insurance 55,000, son's life insurance 1,38,000, family star health insurance 31,000, total around 11,000, 15,000 per annum. Daughter's Tasmika, who's aged 15 years, son who's 11 years old, he is also spending 50,000 towards the children, except the educational expenses. He has also disclosed that paid income tax is 8 lakh rupees for the financial year 21-22. Property owned by him is valued around 8 crores. He has also disclosed that he was self-employed till 31/3/2021 and now surviving out of the rentals of the rental income and past savings, my lord. Now I'll come to the next para, which starts from para 15, my lord. Para 15, my lord. On the other hand, if the particulars disclosed by the respondent in her affidavit filed by the assets and liabilities taken into consideration, whether she has also whereby she has also stated that she's an MBA graduate, now residing in matrimonial house, flat owned by her husband, the petitioner, date of marriage is there, date of separation, general monthly expenses are disclosed as 5 lakh. No approximate expenses incurred on the account of the dependent, whereby dependent being children, she has mentioned approximately 1 to 2 lakhs per month. Their maintenance for food, clothing, medical expenses, extracurricular activities is totally disclosed as 60,000 per month. Further, she has also mentioned so far as petitioners taking care of school and educational expenses of the dependent children. Further, with regard to the educational expenses, educational qualification of the petitioner. She had mentioned DC Diploma in Civil Engineering. He is a building contractor who is engaged in construction work, an apartment and commercial building. I'll take it to your lordship to para 16 now, my lord. If the contention of both the parties as well as the details of the property owned by both the parties and expenses incurred by admission of the respondent in her affidavit makes out, it is the petitioner who is bearing all the expenses, educational expenses of the children, and also their other expenses. Apart from that, he is also bearing medical expenses and medical expenses of the respondent, household expenses. In spite of this, respondent has claimed an interim maintenance of 5 lakhs. Nothing is made out in her affidavit that for what purpose 5 lakhs is required for maintenance of the respondent. Entire expenses of the children, household expenses are being meted out by the petitioner. She denies her employment and status, and the petitioner had deliberately neglected her, and she has not been provided any money for her basic need to purchase anything. He has completely ignored to look after her with the comforts for the past few years. Then, my lord, your lordship may kindly see para 20, my lord. Although a judgment has been stated by this honorable the trial court, I'll come to para 20 first, my lord.
Yes.
Further, the honorable apex court held section 24 has been enacted for the purpose of providing a monetary assistance to such a spouse who is incapable of supporting herself or himself or herself in spite of sincere efforts made by him, or a spouse who is well qualified to get the service immediately. With less efforts, is not expected to remain idle to squeeze out, to milk out the other spouse by relieving him of his own purse by a cut in the nature of a pendant alimony. Para 21, my lord. If the finding of the above referred case law is taken into consideration, even in the present case, respondent is well qualified, but though the petitioner having contended that she is employed, respondent has denied, and on the contrary, petitioner has not produced any documents. She claims that she is depending on her mother and brother, but her own particulars in her affidavit of assets and liability makes out that educational expenses of the children are being borne by the petitioner. She stays in a house which belongs to the petitioner, though there were some properties in her name. And in her name, petitioner is collecting the rent. She also claims that she has personal loan. Taking consideration the source of income of the petitioner, though respondent is educated, as on now there is no document to make out she is employed. On the other hand, what is actual rental income which the respondent receives is also not forthcoming, though there is some credit entry in lump sum to the respondent's account in the month of April, May, September 21, as well as January to March and September 22. There is materials to make out that respondent is having some independent source of income. Taking into consideration the source of income of the petitioner, it is just an appropriate to award 50,000 towards the maintenance of the petitioner from the date of the orders, as the petitioner at the time of argument has submitted that he used to keep cash at home, and whenever respondent is in need of money of her expenses, she has made use of the cash which regularly he used to keep it at home. Further, he had also submitted that even the children make use of the money and they will report to him if at all they have taken cash which he keeps at home for expenses and maintenance. So as all expense of the children are meted out by the children, then respondent do not have any burden to meet the household expenses. What is required is only personal expense of the respondent. So in the circumstances, it is just and necessary this. So it is also recorded that she has a separate source of income in her assets and liabilities itself.
There are some 35,000 or something from the rent. What is that?
35 lakhs has been given by the petitioner to the respondent. That is in para 7, your lordship.
No, not
That was
35
a
lakhs.
hand loan given by the husband.
She has rented 2 properties.
She has, your lordship, para? The rents, my lord. The rents are not going to the petitioner. There is nothing shown on record that he's taking the rent. And your lordship may kindly see forest sector.
It is only allegation.
Your lordship may kindly see for a second para 5, my lord. For a second, my lord.
Come to paragraph number 15.
Of the judgment,
14.
my lord. Para 5, my lord.
Above para 15, 4-5 lines. In the impugned order.
Yes, my lord. The one which I...
Above 15, 4 lines.
Respondent wife is MBA graduate, also mentioned that she is working in rhythm counseling, online counseling services, and she gets a rent from the flat 313, Skion Alavera, Kodiali, Bangalore, 3 bedroom, 3 BHK. Rent per month 36,500, and the rent from Skion Park View of 11,000. It is also disclosed the property.
Evidence to show that she's receiving this amount.
And it is not even received by the petitioner. It is received by her only. She has to show from her account.
It is your case that she's receiving the amount.
Yes, my lord.
So
Because
is there any
this
evidence-
property, if your lordship.
No, they will be paying it through bank account or whatever the mode. In the bank entries, does this amount
No,
finds place?
Yes. May I clarify, my lord? She takes this rent and she puts it in the share market. She doesn't receive it to the bank account. So that cannot be reflecting in her bank account. They pay by cash. So she takes it and puts it in the share market. Your lordship may, for a second, pardon me, my lord, para 5 for a second. Same property, I will show where it is, my lord. The property is 313, my lord. Your lordship may kindly permit me to read para 5, my lord. Only the list of the properties. If your lordship may kindly see D, para D. 3 BHK, flat 313, Skion. This is gifted by the petitioner to the respondent.
It's on her name.
He has gifted it already. It is in her name. This is gifted by the petitioner. And the 1 BHK, all this is his own buildings, your lordship. He was running this Skion Park, which I showed your lordship, it's wound up. It is this all he has built. This 1 BHK, that is C, is gifted by him. D, gifted by him to her. All this property belongs to her. And the third E also, your lordship may kindly see E, 3 BHK, flat 313, Skion Alavera. This has also been given to her.
So these properties are on her name.
On her name, yes, your lordship. And given by the petitioner, my lord. It's a gift deed only.
What do you say about these properties?
My lord, he has made several properties wherein he has purchased few property in my name. Few of them have been purchased in my name, but the document and the possession and the rent, he is only enjoying. That is why clearly I have stated in my evidence affidavit, which I have filed before the trial court. There is no dispute that few properties have been purchased in my name, but I have not seen that property at all till today. Still, because he being a real estate businessman.
Record that these properties are in her name and she is only receiving the rents.
Yes, your lordship can record it. He doesn't have the rents because it is directly going to her share market.
My lord, share
Can
market
be recorded.
will not-
I have
my lord,
stated in
let me
affidavit,
explain few aspects with the stock market, my lord. No single paisa can be credited by cash. Everything has to be transferred through account only. There is a SEBI. My lord, each and every year, if I gain any profit, I should declare it immediately. Or otherwise, nowadays, my lord, the technology has reached that stage that automatically it will reflect in my IT returns. If I gain any profit with regarding. It is not like that I will avoid my account, I will go and deposit in stake market. How it is possible? That is not at all possible. There is a demat account that has to be registered. Through demat account, there will be an account will be attached to it. And through that account only the amount has to be transferred and amount has to be withdrawn to the same account. There is no other alternative options is available. My lord, it is fully secured business of stock market, my lord. Wherein all these allegations she is making repeatedly that I have deposited. Where is that documents, my lord? My lord, there might be a small piece of some amount, 1,000, which is given by my mother, which I have stated myself in my state assets and liability. My lord, even those insurance policies will not feed me any food. Wherein I should admit in the hospital and where I should be bedridden, then the claim has to be claimed by one of the legal heirs, then I will get that amount. And my lord, the insurance policy which he is alleging that life insurance he is paying, I am not beneficiary for it. In case something goes wrong, he will be put into the beneficiary post, not me. My lord, he is repeatedly, the petitioner is saying, I am paying LIC. If something goes wrong, he is benefited, not me. My lord, even health policy, my lord, I should admit in the hospital. That then on they will pay it to the hospital. They are saying that I am paying the health insurance. She is taking full benefit of it. What benefit I have taken? Whether if I go to normal clinic, if I take a medicine from the medical store, whether the insurance policy is going to help me? And there are a lot of procedure where I have taken the use of it. My lord, even the club membership she has shown. My lord, my husband, he's a member. He is a member in there is plenty of clubs wherein automatically when husband becomes a member, they will issue a membership card to me. Let him show a single piece of data whether I have gone and eaten single plate over there during this period when I have claimed for a maintenance. My lord, card will be issued because he is the golden member of those big clubs. Automatically he will receive that club. But what is the benefit? Where I go? But I need some money to go there, no, my lord. Only membership will not feed me. Membership will not give me any reputation there. I need to spend there in order to go there. My lord, even there is 8 crore rupees of fixed deposit which he has invested in Vijaya Bank. And there are 4 crore rupees of in Canara Bank which he has revealed in the assets and liability. My lord, he says that he has paid 8 lakhs where his own document shows that he has paid 33 lakhs income tax during the period when I filed an application. That is what I categorically stated, demonstrated before, because their own document says different and they are making submission different. My lord, one humble submission, my lord. Let them explain in their assets and liability which they have filed before the trial court to say single rupee spent towards me. They are showing their liability towards the child or itself. He is saying in his asset and liability that he is looking after the child. That is not disputed. We are not disputing it. He is paying the school fees. We are admitting. We ourselves saying he is paying. My lord, again and again they are trying to confuse this matter, my lord, wherein there is no single rupee expense has been shown by him that he is spending towards me. And that cash box is, my lord, there is a oral submission she made before the trial court that we have kept a cash box wherein she can take whatever she wants. If that is so, pay through account, no? If you are so glad that you want to help the wife, well, how it can be believable? Even that is not been disclosed in the asset and liability which they have filed before the trial court. If really it is this, the story can be assumed. There is a cash box where she can, how much ever amount she wants, she can withdraw it. If that is the statement, my lord, let them transfer in the account. Even my lord, he has so many properties which have stated in assets and liability, which they also stated, my lord. No measurement of those properties have been disclosed. No value have been disclosed properly, my lord. Wherein hundreds of acres, my lord, where he is gaining income through agriculture, which they are not disclosed before this honorable court. My lord, he keeping in so many agriculture land, measuring more than 100 acres. My lord, whether it can be assumed that he has no income out of that agriculture, my lord. Just because he has not disclosed in his asset and liability, whether the court can be deprived of considering those aspects, my lord. My lord, by this time, my lord, if I have not left my job, I would have been in a topmost position in the bank. I was manager at that time in 2004. By this time, I would have reached the executive post.
Yes, anything else?
My lord, even, my lord, one more submission, my lord. All the transaction amount I have explained in my affidavit, my lord. From mother, brother, all the transactions, whatever deposit, my lord, it can be seen, my lord, how difficult life I'm leading. Gold loans, brother, mother, no husband.
What is she spending for all that? No, you have shown that bank transactions coming the inflow of the amount. What is that you have spent? How much you are spending? Where is that expenditure? Not
Lord,
saying, not giving the expenditure like
my
this.
lord, the thing is, when initially he has started neglecting me, I kept my jewels. I borrowed loan.
Then
For which interest?
You are getting the amount. What is that you are spending for?
Well, my daily needs, my food.
What are they? If you spend anything, you get a receipt for that. Is
No,
it not?
everything will not get receipt. No, my lord.
What else? At least something.
My lord,
You're saying 2.5 lakh rupees. There should be at least 50,000 shows on my account.
My lord, as on today, with great difficulty, by taking help, I'm leading. But I'm entitled to lead such a life, my lord. I'm entitled to lead because the husband is so lavish, he has secured. And moreover, my lord, as being a dutiful wife, I'm discharging all my duty with the best possible ways, my lord. When that being the case, I'm entitled. I'm also human.
MC is still pending 2019. What is the stage of the MC now?
Just it is, the evidence is to commence and.
It is, why is it,
Because the records were called for here, my lord. In his case, records were called for, so the matter is stopped right there.
No, we'll ask the family court to decide this matter by December.
Early, that will be better, my lord.
Yes.
And
Please come.
I have the statements, bank records, BSNL site being bought, gold loans being taken up,
That is
share
transferred by
investment.
mother.
This
That
is all
what I
their
said.
own
It is
affidavits, my
transferred
lord.
by mother.
There is
my-
nothing on record.
Money, you don't have money to take care of. How can you purchase?
I have not
Right.
purchased. I have not purchased.
This is-
my lord,
this-
my mother stays in Andhra Pradesh, and I stay here. And mother opted a site through society where she transferred amount to me and asked me to deposit there. It is crystal clearly. It can be made out in my account statement that she transferred. I transferred to the society. The two installments, my lord. Rather than that, there is no other further transaction. My lord, if someone's asked me, I cannot be. My lord, though.
Please don't, you restrict your arguments. I
Yes,
don't,
ma'am.
don't try to give all hypothetical
Yes.
examples and all.
Yes,
No.
yes.
Please restrict your arguments to the case.
That is what my lord. In the account
This
statement,
is a bank statement, my lord.
my lord,
BSNL.
wherein I have,
Site being
they are
purchased.
alleging that I have a total transaction of 52 lakhs, including all the debit, credit, debit, credit.
Agreed with the order passed in.
One submission.
Yes.
He has a
I
turnover
number
of 53 crores in his bank statement, my lord.
I number 5 in MC number 5279 of 2019, dated 30th September 2023, whereby the court had granted maintenance of an amount of rupees 50,000 per month towards the maintenance of the wife. Agreed thereby, the husband has filed WP number 27917 of 2023 and wife has filed WP number 2232 of 2024. Earlier, when the wife had placed before this court expenses of 6 lakhs and odd, this court has specifically directed the wife to file before this court what are her expenses. Pursuant to the order passed by this court, the wife had placed an affidavit before this court and as well filed the statement showing her expenditure as below. This is 9/9/2024 and there is a table here. Extract the entire table, however it is narrated. And it is stated that she requires an amount of rupees 2,46,300. To that affidavit filed, the husband has filed, not to that affidavit, the husband has filed his own affidavit on 5/9/2024 as per the order of this court. It is a case that the wife, being an MBA graduate, doesn't want to take up any job, not even trying to get a job. The wife account discloses that huge amounts are in circulation in shares, investments and properties to the tune of rupees 65 lakhs 4,018, and she has deposit of thousands of rupees in her account by various people periodically, which is the profit of the rotation of funds in shares and mutual funds as per her own bank statement. The wife is having 3 bank accounts and there is transaction history in every account every now and then. According to the husband, he is taking care of all the requirements and he has also taken the wife to various national and international trips. He is paying the school fees of the children, college fees of the children, and in fact he has paid an amount of rupees 7 lakh 4,000 towards the engineering school fees of the daughter and the son's school fee of 1,35,074. it is stated that earlier he was earning huge profits. The statement that he is earning huge profits is not correct, as he has closed down his business due to various reasons. And he has also placed before the court the copy of the GST cancellation. And he paid taxes regularly. For the assessment year 2020, 22-23, the turnover is 49,95,180. And he had paid 30,80,269 as tax. For the year assessment year 2023-2024, that 54,31,780 is the turnover, and the tax he paid was 17,33,443. According to the husband, he has paid an amount of rupees 31,25,000 when asked by the wife where she wanted to help her parents. And the statement of the account details of the wife and what are the amounts as also stated by the husband. You submitted that when the husband is spending all the amounts, it is not the wife is not entitled for any maintenance. For that, a reply is filed by the wife stating that all those amounts are borrowed, whatever the transaction of 65 lakhs and odd, all those amounts are borrowed from the family members by pledging the gold ornaments. And a very small amount, she is doing the share business, which is a very small amount. And according to the wife, husband is leading a lavish life, and all the cards, the club membership, all is shown. She is never utilizing the facilities, as is having is a gold card. The add-on card was given in the name of the wife, but she never availed it. According to the counsel, the insurance what the husband has placed before the court, the wife will be able to get the same, provided she is hospitalized, but her regular requirements of medical needs, she cannot, which she cannot, that the policy is of no use for her. Even the life insurance is also of no use to her, for her, as far as her day-to-day requirements are concerned. It is submitted that though it is for the, according to the husband, she is having so many properties, there are certain properties purchased on her name, and she is getting income. According to it is submitted with the land council that those properties are not the whatever the rental income that is enjoyed by the husband, and she do not have the documents, nor she is aware of what are those, where are those properties. It is submitted that, as stated by her, she requires those amounts. Next para. The trial court, by order impugned, had granted maintenance of an amount of rupees 50,000. The court had considered the respective contentions of both the parties. that the all expenditure pertaining to the children are borne by the husband, and she stays in the house which belongs to the husband. And according to her, she has personal loans. There is no document on record to prove that she is employed. On the other hand, what is the actual rent income which the wife receiving is also not forthcoming. Though there is some credit entry in lump sum to the wife's account in the month of April, May, September 2021, as well as January to March, September 2022, there is a material to make out that the wife is having some independent source of income. Considering the requirements of the wife, the court had granted 50,000 towards the maintenance. The court also observed that it is a contention that the husband used to keep hard cash at home, and whenever my wife is in need of money for her expenses, she make use of the cash which regularly used to keep at home. And even the children also use the money, and they will report to him. The court observed that when all the expenses of the children are meted out by the husband, the wife do not have any burden to meet the household expenses. What is required is only for the personal expenses. Accordingly, that amount is granted. Next one. Having heard the counsels on either side, there is a material on record. The undisputed facts are that, in view of the strained relations between the parties, the husband had filed MC number 5279 of 2019 seeking divorce, and the wife and husband, along with the children, are staying in the very same house. According to the husband, he is taking care of all the requirements, medical, personal expenses. All expenses are taken care of, the children's expenses, and the wife do not require any amount. It is his case that he is keeping a box where the amount is kept in that, and whenever it is required, both children and wife are using it. According to the husband, yes, he has executed a gift deed in respect of certain properties, and the wife is receiving the rent from that. According to the wife, those properties or those stands in her name, but she has those documents are not with her. She has no knowledge about where the properties are situated. It is the husband who is enjoying the properties. Undoubtedly, undisputedly, there is a cash flow in the account of the wife to a tune of 65 lakhs and odd. Both of them have their own versions about the same. According to the husband, she is doing the share business and she is getting the income. According to the wife, she is getting it. She has borrowed the amounts, and that is the inflow. The counsel appearing for the wife do not clarify why a lady, when according to her, all the expenditure pertaining to the children are taken care of by the husband, why she is requiring a huge amount of 65 lakhs for her personal expenses. What are those personal expenses? This court is not able to understand. Earlier, when an amount of rupees 6 lakhs and odd was shown to be the income, this court has asked the wife to come before the court with exact amounts, but not the exorbitant figures like earlier. But again, the wife has come before the court with the same prices, the same amount where she says that for food expenses at her residence, she requires 40,000 per month. And towards clothes, as the husband is using all branded clothes, she requires 30,000 per month. And towards the medical expenses, she requires 41,000 per month. And for the daily women accessories, she requires 15,300. And for general medical expenses of children, she requires 10,000. For recreation with the children, she requires 30,000 per month. Toiletries and laundry expenses, 5,000. And for the eating the food outside the house, 15,000. Towards the legal expenses, 30,000. And towards the loan which she has borrowed to maintain herself, she requires another 30,000. Altogether, an amount of rupees 2,46,300 is required. When the husband is taking care of the entire necessities of the children, the wife has asked for 2,46,300 as maintenance. It is a contention of the learned counsel that as a husband is having crores of rupees, the wife has to lead the same, has to lead her life in the same standards. As such, she requires these amounts. The expenditure, as stated by the wife on the face of it, shows that in spite of repeated orders passed by this court and also cautioning the wife that if the kind of exorbitant figures were stated before the court would dismiss her petition. In spite of that, she has again come up before the court by giving these kind of figures. Just because the husband is having income and according to her, he is well placed, for her food, she doesn't require 40,000 per month. And all other expenses that are stated are on the higher side. No doubt, as far as a medical requirement are concerned, wherever there is a policy, all those the amounts they're entitled provided there is a hospitalization. For the general medical expenses, they will not be getting the amount. For the general expenses, that policy would not be of any help. And even the life insurance policy also would not be of any help as far as meeting her day-to-day requirements. Even when the wife is staying along with the husband, as rightly observed by the trial court, she requires certain amounts for her maintenance. This court has perused the income tax returns for the year 2021, 2022, 2023, and 2021, 2022. That clearly shows that the husband is earning sufficiently. The wife is having a medical issues with regard to the knee joint pain, where she has to take regular medication and physiotherapy. She requires some amount towards her medical needs. Then coming to the other requirements, in the considered opinion of the court, some reasonable amount she requires for her to spend for herself, though she is living with the husband and he is taking care of the other needs of the wife. And even if, as stated, if she has to take care of the requirement of the children, though husband is taking some contribution whenever required to take them out or to to make them comfortable, she may also have to spend certain amount. In those circumstances, the amount that is awarded by the considering the financial capacity of the husband, the amount that is awarded by the family court is a reasonable amount, and this court finds no reasons to interfere. Accordingly, the writ petition filed by both the wife and husband are dismissed. The MCs of the year 2019, the court shall make all efforts to dispose of the MC by December 15. Yes.
One submission.
Cell number
That the lower court has ordered to give maintenance from the date of order instead of from the date of application. As per the Supreme Court guidelines, my lord, the application has to be considered from the date of
The
application.
court has also explained, my lord. Earlier, the
No
money has been
explanation.
taken care,
No
cash was
explanation.
kept and she was using it.
No
That is the
explanation.
reasoning given by the court, my lord.
The court had granted the maintenance from the date of order. It ought to have been from the date of petition, because there is no change in the circumstances from that day, to the order of the day, as the wife still continued to stay with the husband, was staying and still continued to stay the husband. So the court cannot make out this case is not a special case where the maintenance has to be granted from the date of the order, but it should be from the date of petition. Yes.
My lord, this honorable court,
Partly allowed. Yes.
this honorable court, while hearing the matter, my lord, they reduced it from 50,000 to 25,000, which I have been regularly
was
paying
the
to the party, my lord. I may be permitted to pay the same 25,000 because he is taking care of all expenses. And now his company is wound up. He is also in difficulty, my lord. And he is taking care. I have produced all the records that she has 65 lakh rupees rotation. She doesn't need even 1 rupee from him. Then also this honorable court can grant 25,000. He's already debts, my lord. He has a lot of expense.
That is his earlier venture.
Income tax for the each year what I have produced, if I can explain your lordship.
There is 24, 25.
I'll produce it, my lord, because once the company is closed, my lord, he's only depending on the rents. He doesn't have any business. And I produced the registration certificate also.
Already he was paying income tax of 18 lakhs, 20 lakhs, 30 lakhs.
That time when the company was there, my lord. After it's wound
material
out.
to say that now the situation has changed.
Yes, I have produced that income tax after the company has closed down,
Where is
which
that?
is reduced. Your lordship may kindly see
How much
page
is
12.
that? How much is that?
I'll tell, my lord. It has got reduced after the business has come down. I'll show, which is already in the part of the record also, my lord.
He has closed the earlier venture and doing the new project now. He has closed the GST with respect to that project, and they are misleading the court and trying to take the advantage of that earlier closed project, my lord. Now he is into new project. And my lord,
This one. This what has been produced before this honorable court is the FD of the amount given on the lands being purchased. It is not his income. What he has taken, borrowed from the people who purchased the land, what advance they gave, my lord. Only with that he is earning that interest, which he has to register the property to them.
Where are the income tax returns for the year so and so?
What is the income tax? For your lordship bonds 23 and 24, my lord.
And 24 and 25 also.
23, 24 and 24, 25, what is the income tax?
70 lakhs in the 20 lakhs.
How much?
Around 50 lakhs.
Around 50 lakhs he has paid the income tax. 20,000, 20 lakhs, it's tax alone, my lord, in that.
Yes. Yes, next.
my lord, instead of petition, my lord, from
The
the interim
matter, your
for the
lordship.
clarity, my lord, interim application.
Application from the date of application.
Much obliged.
My lord, the matter to be disposed of, your lordship wanted to observe.
Already
Before
December
December.
15.
Please.
Yes. Yes, next.
Cell number 41, Amar Korea, practitioner. P. Prakash.
That I represent the respondent, my lord.
Yes.
Yes, madam, the last occasion direction was issued to us to file an affidavit from the wife as to why she is not working. We have filed an affidavit, my lord,
Yes.
and she's also before the court.
Where is the affidavit?
Yes, my lord, we have filed it to the court.
Dated?
Yes, my lord, on 13/8, my lord, 13/8,
38, yes.
13.
Yes.
Yes, you narrated, my lord.
Hmm.
Lord's order of this honorable court.
What are the efforts she has made? What is the reason for filing this affidavit?
My lord, we are only saying that it is because of the serious setback in her life, she could not come out of that particular thing. Because in our community, there is no possibility of second marriage also. Now it is he who has suppressed all these material facts and entering into the marriage. Within 3 months, she has come out of that marital home.
Correct. When she came out of the marriage? 21.
In the month of
21
May.
minutes.
In the
Then
month
in
of May.
2025.
Yes,
Forever she'll be in the same depression.
My lord,
So if she is under depression, what is she doing?
she's simply silently sitting in the house, in her parents'
And
house.
then if we
I've
don't.
also discussed
if-
with her.
No,
and
no, if we don't grant the maintenance, she will work then. That is not the answer at all. What is MTech in biotechnology?
Yes, my lord. She is having that because of these reasons. She has lost all that interest. in her.
If these reasons, then that can't be that cannot be a reason.
Because that's the false
Hello,
allegation
that's-
that they have been all through making, Lords. In fact, there is a medical report also which we have produced before the trial court. She has filed divorce petition on the grounds of cruelty, mainly contending, Lords, he was impotent and that caused cruelty to her. He has filed a divorce petition on the grounds that marriage did not consummate because of the conduct of the respondent, because she was not cooperative and she demanded the lavish life exceeding his capacity, Lords. That's what he has.
May I
What is
just-
his income?
Well, what
What
are
is
our-
the
Lords,
income?
his income is 58,000 rupees per month.
Court has granted how much?
Court has granted 15,000, Lords. This court has made it 5,000, considering there is already a 5,000 which was granted in DV proceedings. Hardly she stayed for 2 months in the matrimonial house. Lords.
What you do is you continue to pay this amount for 6 months. You continue to pay this amount for 6 months. Let her make her efforts to get the job.
Yes, madam. We
And
will-
the court shall revise this order basing on that.
Please, ma'am.
The family court shall review the order.
Hello, 1 minute, madam. May I just make one submission? They are relying upon some certificate alleged to have been issued in some Tamil Nadu.
We'll not go into that.
He is-
We'll
she
not
is
go into
making-
that.
He is physically incapable. He is physically incapable.
Not into that.
That is
issue
what
at
was,
all.
that is what was
Yes, that's
examined
what-
at the
yes,
instance
filed
of
the life
her
of-
and the police, my lords.
Agreed
She
with the orders
she
passed
goes and
in
files a
9 number
complaint on
1,
the same
PMC
allegations.
number 418
That
of
was that is a
2021,
medical
dated 22nd
report.
April 2024, whereby the court had granted maintenance of an amount of rupees 15,000 per month from the date of the petition till realization the husband is before this court. Land counsel appearing for the husband submits that. Both of them have stayed together for how many days?
2 months, my lords.
They have stayed together for 2 months.
That is a major.
2
In
months.
the month
And the
of
wife had
May,
filed.
in the month of May, she has come out of that matrimonial.
In fact, has,
It is they who have pushed her away from the house.
you are arguing as if I'm deciding the divorce petition.
That's right. Because so far as the
Both
factual
the
aspects are
petitions are
concerned.
pending.
Hello,
Both the
factual-
factual aspects are.
That is her contention. You can tell what is your contention also. I'll record. It is submitted that the marriage lasted for 2 months. 2 months, and on the ground of she has filed a petition seeking divorce on the ground of impotency.
Yes, please.
And you have filed MC on the ground of divorce. She filed a counterclaim.
Yes,
My
she
lords,
has also
she
filed.
files
She has also
initially
filed.
and then I file a counter petition.
Then the
seeking
husband has filed a counterclaim on the ground of cruelty. It is a contention of the land council appearing for the petitioner wife, the petitioner husband, that the wife is MTech. She's a She completed an MTech in biotechnology, and earlier she was working in Nelson Market Research Company. She has also filed a petition under the DVC Act.
DV Act and yes,
also we have filed.
The Act, and court had granted
5,000,
an amount of rupees 5,000.
which is being paid, my lords.
Which is being paid by the husband. Now the court had granted 15,000 as maintenance, and the income of the husband is
58,000 rupees.
58,000.
Altogether,
And,
8 lakh.
and my lords, he has in his assets and liabilities, he has shown liabilities of my lords 40,000, 38,000.
And counsel submits that the wife who has stayed with the husband for 3 months, thereafter, when she is very much qualified, she has not taken any steps to secure the employment, and one in DVC and other in the IA for interim maintenance. She is seeking maintenance, and court had granted now 20,000 per month. It is submitted that the wife is capable of earning, and she cannot sit idly and depend upon the husband for maintenance. Then counsel appearing for the respondent submits that, respondent wife submits that as per the order passed by this court, what are the efforts made by the wife to secure the job? They have filed an affidavit before this court. It is submitted that because of this harassment and because of the outcome of this, the strained relations, because of the impotency of the husband, the wife is undergoing tremendous pressure and she is not in a position to work. It is submitted that in her in the society or the community which she lives, second marriage is not an option, and there is a lot of social stigma attached to it. As such, she is not in a position to work, and she could not make any efforts to secure the job. Next para. Having heard the counsels on either side, there is the material on record. The wife and husband are qualified. Particularly, the wife is MTech biotechnology. She did her MTech biotechnology.
She's more qualified, in fact, my lords. Mine is BTech, my lords.
He is a BTech graduate, and she is an MTech postgraduate.
External MBA later.
He has done MTech also.
MBA. He has done MBA later.
And wife has done MTech biotechnology. And earlier she was working. The marriage, according to both of them, has lasted for according to you, how much?
According to me, up to 4 months.
According to the husband, 2 months, and according to the wife, 4 months. That is from the year 2021, they are separated. The reasons that are stated by the wife that she is not able to secure a job, or she has not made any efforts, or she is under tremendous pressure, cannot be the grounds for the wife to sit idle and seek maintenance from the husband when she is competent to say, when she is qualified to secure a job. In the considered opinion of this court, the wife cannot depend upon the husband forever without even securing a job. For that reason, the court wanted to know what are the efforts made by her for securing a job. It appears from the affidavit filed, no efforts are made, and the reason for that is a mental stress. In these circumstances, this court is passing the following order. Number 1, the husband shall continue to pay 10,000 to the wife till for a period of 6 months from today. And the wife shall make all her efforts to secure a job in this 6 months. Next, the husband is at liberty to approach the court after 6 months to review this order, and the wife would also be given an opportunity to place before the court what are the efforts that are made to secure the job. Basing on that, further orders shall be passed by the court. Accordingly, the petition is disposed.
10,000, 5,000 in this petition and 5,000.
5,000 in this petition, and
that may be
as he's already paying 5,000 in the other petition.
Please.
Bill number 45, Pratima SK.
Yes.
The petitioner is the mother.
appear for the respondent one.
Then counsel for the respondent father submits that the petitioner wife is not complying with the order passed by the family court.
Please, my lords. That
Let me
remains
just-
the same, my lords.
Let me just clarify that. The court
What is the
passes-
order?
Because this is a visitation order.
Let's see, page number.
My lords,
63, my lords.
may I just come to relevant parameters?
Filed by the petitioner father is permitted to meet the child on every Sunday from 10 AM to when he is permitted to take with him to the park or shopping mall by keeping the point of security to the child. Permitted to talk with the child, so and so. Meet the child on the birthday of the child for 2 hours with prior information. So and so. When is this order passed?
June
this was
18th,
passed in
my
June.
lords. Exactly 2 months before, my lords.
June?
2 months before, my lords. June 18th. 17th. Pardon me, my lords. June 17th.
Huh.
Plus, may I just take your lordship?
Is this order complied
No,
with?
my lords.
I'll just come to that. I am before this court. Plus, para number 12. Plus, in this, the court says that both the parties are residing in Bangalore. The address of the petitioner and the respondent is shown as Bengaluru city. The child is residing with his mother in Bengaluru itself. Yes, child is residing with the mother in Bengaluru. However, the father is not residing here at all. He resides in Mumbai.
How does it make any difference?
Annexure C, my lords.
No, how does it make any difference?
No, I'm just telling what exactly are the facts. Petitioner and husband, after having got married in 2012, 2013 the child is born. 14 she's thrown out of the house. 16 he files for divorce. From that day to this day, my lords, he has not made a single effort neither in maintaining the child nor in coming and visiting. Even after this order was passed on 18/3, 12/3 or 18/3, my lords, there was birthday of the child. He never made an effort to come and even visit the child or give any gifts or whatever it is. The maintenance order that is passed, my lords, has not been complied. So much so that 8.5 lakhs.
So if he is not coming, why should the mother come before the court seeking modification?
Why the court should have ascertained the views of the child being of 12-year-old. Never seen at all. The father has never seen the child. How he can be directed to just go with the child?
No,
my lords?
because something has gone wrong, that forever it should be like that.
No, I'm not saying that.
Then
let the child be
the mother should
called.
also make some effort.
Let the child be called because he is 12-year-old. Let the views of the child be ascertained, and whatever is the counsel.
No, without even calling the child, when the
Lords.
counsel is submitting that the child should be called, without even calling, I can understand what are the views of the child.
Please, my lords.
Not at all. That should not be this thing, my lords. The court has to ascertain independently the views of the child. In fact, my lords, the father had give up.
Let us assume that the boy says that he is not interested to meet the father. Then what is to be done?
No, how can the mother be held? He is going on telling as if the mother has kept the child. Mother is not interested in keeping the child away from the father. Not at all. Why should she? Because he has not made a single rupee for the educational expenses.
What are the efforts made? What is the violation of the order?
My lords, I'll take to the impugned order only, my lords. It has been 2 months, my lords. I am the counsel on record before the family court also, my lords. I have made, me being as a counsel, made genuine efforts to contact the advocate on record. There is no reply. The counsel on records junior will tell that I'm in the hospital, please contact. I'm asking, please give your senior's number so that I can contact and make. My lords, it has been 12 years, my lords. He is crying on the phone, making efforts day in and day out, my lords. Even the address were not disclosed to the father, my lords, in 2016.
May I?
My lords, it's been 12 years. 2 months, my lords.
He is the 5th counsel on record.
That
After
doesn't
your
matter, my
lordship
lords.
passed-
I
No,
might
one
be
minute,
the
1 minute.
10th.
After your lordship passed an order that hand summons has to be served, on that day, this advocate has come on record.
Is it wrong, my lords? I am
No, I am
I'm
not
genuinely
saying it's
asking,
wrong.
is it
The counsel is not aware
me
what
doing
has
my
happened
duty? Is it
earlier.
wrong? Yes, my lords, I'm the counsel.
That is all I'm
Since 2
saying.
months, I'm the counsel. Please, my lords, consider this. I'm trying to contact the advocate on record. Lords, at least the number of the senior who's standing here, that number is not furnished, my lords. I'm making my genuine efforts to contact the mother, my lords. So that I get, my lords, I have the WhatsApp conversation of father. He has made the payment of 2 lakhs. Even
After
my
filing
lords,
of this writ petition, he filed, and educational expenses from
Please,
21,
my lords, I
22
filed a
has
memo
been
to that
directed to be
effect.
given. Not a single
Please,
year he
please.
has paid, and an amount
filed
of
a
8
memo
lakhs
to
is
that
pending.
effect, stating that the bank details were not furnished.
And
my lords.
wherever the address is shown, she is residing there. What is the need to contact the councils and communicate? My lords?
Because I don't have the contact number of the petitioner,
The
my
I
lords.
number 8, the order impugned is passed on I number 8 in MC number
In fact, there is
3930.
another WP also, my lords.
It is 17 June 2025, whereby the family court had granted visitation to the father on every Sunday from 10 a.m. to 5 p.m. and is permitted to take the child with him to the park or shopping mall by keeping the point of security to the child. And also he is permitted to talk with the child over phone in the schedule. Further, father is permitted to meet his child on the birthday of the child for 2 hours by prior intimation to the wife in a park or hotel without affecting the health and security of the child. According to the mother, according to the counsel appearing for the mother, the child is not interested. The father has not taken any efforts to meet the child and has not taken care of the child at any point of time. Child is 12 years and the court ought to have interacted with the child. The counsel appearing for the respondent submits that in spite of his best efforts, he could not meet the child because the whereabouts are not within the knowledge of the father, and the father is ready to take care of the maintenance of the expenses of the educational and other expenses of the child. But even those details, the bank details and other details are not given to the
No, they
husband.
never sought
Please,
for.
my
My
lords.
In fact, the father has transferred an amount of rupees
2 lakhs.
2 lakhs on what date?
My lords, in the month of, from June to August.
Not June to, I can tell it is in this month.
In the month
I can
of
tell the
August.
dates.
In the month
In
of
fact,
August,
yesterday,
the
I think it
amount
was
is,
transferred 1 lakh.
Transferred.
Sorry, my lords, 50,000 yesterday.
Yesterday, 50,000, yes.
Total 2 lakhs or 1 lakh?
Total 2 lakhs, my lords.
2 lakhs is transferred. The order is passed on June 17. This court has not passed any interim order in this. It is a duty of the mother to comply with the order passed by the court. On the coming Sunday, that's on 24th of August, as per the order passed by the court, in the presence of the mother, the father shall exercise visitation. And basing on that, further orders will be passed. If by any chance the mother fails to comply with the order passed by the family court, the further orders would be passed considering the conduct of the mother. This matter
Let's let it.
on 28th
29th,
of
my
August,
lords. 29th, my lords.
29th of
Plus
August.
the visitation, should it be in the apartment where they are staying?
As per the same, as per the
Which
terms of
there is no, it just
outside, he
says.
said.
My lords,
out-
if they
The,
share
as
the
per the
contact
order,
details.
he can take him outside.
Plus, as per the order, the father can take the child to any mall.
I
or
said the
park.
same conditions, mother will be present.
Plus 10 to 5, how will the mother, she's also a working lady.
It's
Sunday.
If it is in the apartment, then she can accompany.
But the apartment, what they will do from 10 to 5?
There is a big area there also.
Then mother need not let the child, the mother's presence is not required if it is in the apartment.
She is fine, but the child is not going. That is, I'm okay to keep the child even here present, my lords. I'm perfectly fine.
First of all, let the order be complied, then the court will meet the
Just to
child.
comply the order, the mother has not said she will not
Then
comply.
shall
The father has
if
not made
10 to
affairs.
5, what we do is on Sunday,
Please,
between 10 and 2.
Between
On-
that.
All right,
On,
10 and 2,
on
I could
Monday,
tell her.
on Sunday between 10 and 2, the father can take the child outside to the shop, to the mall, like look at it in the order, whatever conditions, so and so, in the presence of the mother.
Mother, that's all right. My lords, may he be directed to pay the educational expenses, that is.
All not at
amount.
once. We'll hear on the day when I hear the matter.
Lords, let them share.
And on list this matter on 28th, not 9th is not possible. If not 29th, it'll have to go on Monday, September 1st. And on
First
the
is
day,
okay.
on the day, the mother and the child shall be present before the court in the
First, my lord.
chambers.
First
Evening.
evening.
5
Yes, next.
Cell number
Let
40.
them share the contact details, my lord, so that I can contact them on 24.
The
But
council.
they have been asking my junior who was not well for the number, my number.
Counsel for
Please,
the.
However,
correct,
I
And
will not
counsel
be
for the
able to
petitioner
coordinate.
shall share the details with the counsel for the respondent. Yes.
Cell
Let
number 40.
the parties communicate.
Where do I
between
go and
themselves.
communicate, my
Yeah,
lords? I
he is
don't have any
residing
contact
in his
details.
main address.
Let them
Why
furnish
would
the address, my
councils
lords.
be troubled? I'm not able to know. They
No, my
sent
lords,
a
let them
long
furnish
mail
the
and
address, my lords. This is what the,
send the mail.
my lords, this is what my client is asking. Where do I go and contact? Where do I go and
We are
contact?
not any kind
He has
of.
some 5 to 6 numbers, my
One
lords.
thing, you go to the apartment, address
Yes.
and she doesn't comply with, then he should at least have the
Then
phone
let
number.
him
Please,
inform
my
me,
lords.
that is all.
No, phone number, he should have somebody's phone number.
He has my
No, my
colleague's
lords.
number. He
My
has
lords.
contacted my
Ah.
colleague. How can that be?
My lords, she is not ready to furnish
He
the
was
senior's
not
number, my lords.
well.
What do
Where
I
is the
do, my
wife's
lords?
number?
For this, my lords?
Do you have your wife's number or not?
No, my lords, I don't have.
He just said WhatsApp I have sent. How he can say like that?
WhatsApp to me, my lords. My client has sent a message that I have paid a
It's the
50,000.
same
He
number
has
they
only
have
the
sent.
bank details, my lords.
Address that she's
The learned
residing.
counsel for the petitioner shall give the phone number of the petitioner
I can
Please,
give
my
it.
lords.
to the counsel for the
Counsel,
respondent. Yes, next.
Cell number 48. Ravishankar Shastri G for appellant. B.C. Shivanya Gowda.
Where is he? No representation for the appellant. Liz is matter for dismissal on 16th of September.
Cell
Counsel
number
for the
49.
Yes,
Gurdev Prasad KT
this also for dismissal.
on 16th.
Dismissal. Yes, counsel, no representation for the appellant.
Yes.
Counsel for the respondent is present.
Next week, Lordship.
Same, like in the other case, same date. Yes, next.
54. Cell number 54.
Yes.
Lordship, I don't have other records. I have only judgment copy. If you
2023 MFA,
No,
why are you not
tomorrow
having?
only, tomorrow only. Lordship,
Tomorrow, the short dates are not possible in this court from now on. This is matter on 16th of September. By the time the learned counsel for the petitioner, appellant shall serve the copy of the appeal memo on the counsel appearing for the respondent.
Cell number.
Yes.
List number 2. Serial number 1.
Appellant, sir.
Number 2, serial number 1.
Needful is done, sir. PIP is paid. Needful is done. PIP is paid for respond number 1, sir.
Give it.
How, sir? Morning ಕಟ್ಟಿದ್ದೀನಿ
The order sheet.
Morning I pay, sir.
It is submitted that the needful is done. Read from the caption for dismissal list after service of notice. Next two.
Serial number 2.
The counsel on record is unwell, Milord, for the last 1 week. She requests a short accommodation, Milord.
A week's time is granted for paying the process, or else the appeal shall stand dismissed without further reference to the court.
Serial number 3.
Delete from the caption for dismissal.
Serial
Yes.
number 3.
I appeal for petition and discuss.
IA number 1 of 22 is filed to condone the delay of, give the condone delay petition.
This is ex parte order. Ma'am.
Read paragraph number 3 of your affidavit in support of the condone delay petition.
I state that in the month of May 2022, I have received summons issued by Principal Judge Family Court, Shimoga, in criminal petition, criminal miscellaneous number 12/2019, recovery of arrears of maintenance, and immediately after knowing the same, I have contacted to advocate and requested to verify the same, and advocate applied certified copy of 3/5/2020 and received the 787 ಇದು criminal recovery petition.
Mic use ಮಾಡಿ, mic bend ಮಾಡ್ಕೊಳ್ಳಿ.
This is criminal recovery petition. Main petition is 130 of 2000. 130 of 2018. This 125 proceeding.
What happened? Why, what happened to the notices?
The ex party.
TCR is there? Call for the TCR. This is matter on 23rd of September. Yes, released from the cap. It is in dismissal?
And it
Or
is,
delete?
for
Yes, next.
sale number 4 and 5, 4, 5, 6 urgent, sale number 7. Why we ready?
7. Lodge, request to lodge to kindly next Monday, man. Short.
Why?
Lodge, my senior is not well.
This is matter on 13th of October at the request of counsel, the appellant. Yes, next.
Sale number 8, Manjunath ND. Sale number 8.
No representation on behalf of both the parties. This is matter for dismissal on 23rd of September.
Sale number 9.
Appellant in the connected
What
matter.
happened to him?
Sure.
In the forenoon as well as in the afternoon? There is no representation on behalf of the appellant. Counsel for the respondent is present. This is matter for dismissal on 14th of October. Yes, next.
Sale number 10 urgent. Sale number 11. Sohani Holla.
Same for dismissal on 18th of September, no representation.
Sale number 12 urgent 13.
This also. This is a matter for dismissal on 23rd September, no representation in the forenoon as well as in the afternoon. Next.
Sale number 14. Vijay Kumar T.
Case of injury for enhancement. Madam. Lord, the
Give the
accident,
file.
the accident occurred on 29/4/2017. madam.
29/4.
2017.
Where is the table?
Madam, kindly,
Page number?
please. madam.
Page number 23 of the judgment.
23 of the judgment. Madam. MEC number 4149.
4149.
49 of 17.
You said paragraph number?
23 of the judgment, my lordship. Paragraph 36, my lordship.
23. Madam. 23 of the judgment. My lord, the income taken, my lord.
Interestingly, in the judgment, after 22, there is 23. It's there. There is no table.
Table is there.
Table 23. 23 of the judgment. Madam.
Page number 23, paragraph 36 of the.
You are referring to the judgment page number of the judge. Yes. What are the injuries?
My lord, injuries are fracture neck, right femur, head injury with yes,
Two fractures.
fracture neck of scapula with fracture right navicular. My lord.
What do you say parents suffering?
My lord, the disability assessed, my lord.
Under 20,000?
3,000 as awarded, my lordship.
No, two fractures and also a head injury.
Head injury, they have not stated anywhere in the orthopedic surgeon only they treated the doctor, my lordship. They, regarding head injury, they have not examined any doctor, my lordship.
No, but the wound certificate says so. So another 20,000, 80,000. Next, medical expenses as it is.
Please, my lord. Food and nourishment, my lord, 50,000.
Mr. Counsel will go. We are
45
on,
days inpatient.
we are at serial number 2. Please look at the table. We will go one after the other. So first medical expenses as it is.
As it is.
2,52,000. Then loss of income during laid up period. What is the income?
25,000 was taken by the tribunal, my lordship.
How much?
25,000, my lordship.
25,000, my lord. But as per offer letter issued by the my lord
So
concerned.
25. How many days you are in hospital?
45 days.
25 days.
This one is for 25 days. Sorry. Next case.
So how many months it is granted?
6 months. my lordship.
But then what
Months
else?
grant.
There is nothing to increase this amount also. Then loss of future income.
Future income concern, my lord. The tribunal taken only 25,000 per month, my lord. As per my lord, kindly come to.
What happened, madam? They have produced the offer letter, my lordship. They have not examined the fees, or they have not examined the author of the document. On the
Kindly.
basis of earlier where she was getting salary, that much are taken. Because on the education only 25,000 was taken as granted the income, my lordship.
If you want that, you examine, you ought to have examined, and even now you want to examine, I can remand the matter, but basing on just a letter, without examining anyone, we cannot.
My lord, kindly for a minute, my lord.
Could have examined
Para
somebody.
number 30, my lord. Para number 30.
Please read.
My lord, insofar as her avocation and income is concerned, the petitioner has produced exhibit of P14 online copy of appointment letter dated 31/2015. Though on perusal exhibit P14, it showed that the petitioner had been
You are
offered.
working now?
No, my lord. No,
An
my
offer
lord.
letter, my lordship.
And
You are not
also, my lord,
examined, it is the online document.
at the
That's what
time
I'm
of the
telling.
accident, my lord, I
No,
was
if you
working,
want to examine,
acting as a serial actress, my lord. Due to the accident and disability,
how much is the
couldn't able to-
disability?
my lord,
How much is the disability?
16%. 16%.
48%.
18% was taken by the tribunal, my lordship.
18% has been taken by the tribunal, my lord. My lord, as per the offer letter, per annum, my lord, 6,50,000, my lord.
Why you are not able to do the job? How the disability is coming in the way of your future
Because of
income?
the fractures and disability, my lord, I couldn't
You
able
sit
to
and work.
continue in that. Kindly,
No, you're a software engineer.
please, my lord. That is the only, my lord,
If you
ground.
want the matter to be remanded, I'll remand, or else at 25,000 can only be considered.
Kindly have it to day after tomorrow, I will come.
Day after tomorrow, at
Please.
the request of one counts for the petitioner, the appellant. Yes, next.
Next matter, kindly have it day after tomorrow. Both are
Connect.
rising out of same judgment.
Day after both.
Please.
Next.
Then number 16, Chandrasekhar.
Owner's appeal, my lord, case of death.
Huh.
Cha-
Who are the
Question-
respondents?
Respondent,
All private respondents.
private. my lord.
Owner of the vehicle is who?
Owner is the appellant, my lord.
Oh,
Owner's appeal.
These are all the
Challenging
claimants.
the liability as well as the quantum.
Yes.
Case of death, my lord.
You are questioning the liability on what ground?
That the deceased was aged about 16 years, had no license, and negligent on his part. He hit my lord, the tractor parked on the right side of the road. This is negligence due to which, my lord, the accident occurred. That has not been considered by the honorable tribunal.
Filed against whom?
My lord,
Charge sheet is filed against whom?
charge sheet is filed against, my lord, the owner of the tractor and the driver of the tractor and owner of the two-wheeler, which the owner of the two-wheeler allowed the boy to ride this bike.
Court has not considered the contributory negligence.
Not considered.
Mm.
Then, my lord, my lord,
First of all, let's see how the accident has taken place.
Lord, kindly see. Come to, my lord, para 7, page 22, running page 22, my lord. Reasons, issue number 1. May I start from the petitioner number 1, PW1 Chandrasekhar K, son of so and so, is father of the deceased, has deposed in accordance with the petition averments that the son Chetan Kumar had died due to the road traffic accident that occurred on 12/12/2017 at about 6:30 p.m. at so and so Tankburn Road near Honnalgere village while he was riding on his motorcycle bearing register number so and so, and on account of rash and negligent driving on the part of driver of the
Eyewitness to the incident.
I have not examined, my lord, the eyewitnesses.
Not you.
They, my lord, nor they, my lord. Only his the claimant and another Vishakante Gowda.
That boy was examined,
He's no more.
pillion rider.
There was no pillion rider. He himself was riding the bike.
Look at it.
Along with pillion rider, he was no.
There is a pillion rider.
Yes, my lord. When he was standing and chatting with his friends, a boy was coming on the left side of the road on a bike with pillion rider from the direction of K. Hunnalagere. At that time, the driver of tractor and the trailer bearing number so and so, who was driving in a high speed in rash and negligent manner from the opposite direction, drove from the left side to the right side and hit the said motorcycle at around 6:30 to 7 p.m. in the evening. As a result, the rider and pillion rider fell. One of them had sustained injuries on his head and other parts of the body and had lost consciousness.
Where is the scene of that sketch? Show the sketch. Exhibit.
Exhibit, my lord.
Exhibit P2.
Yes, ma'am. Spot master.
Exhibit P2.
Spot Mahajan with spot sketch.
That's in Kannada.
Sketch is that.
ಇಲ್ಲಿ ಈ ತರ ಇದೆ ನೋಡಿ. Hunnalagere is the left side, my lord. From left side, it is Topanhalli. The case of the claimant is that the tractor was coming from Hunnalagere. My case is that it was parked on the right side of the road, but in the Mahazar,
it is moving.
They say it was moving, but I say, my lord, it was parked.
If you say parked, then you have to prove it that it is parked.
But in the Mahazar also it is shown on the left side of the road. And the driver
supposed to be No, when you're going from what is that? Jonnalagiri? What is that?
Hunnalagere.
Hunnalagere, from there to this
Topanhalli.
side.
Topanhalli.
If you're going, you should have been on the right side, but you are on the left side.
Yes, ma'am.
So that is gone. Next.
But negligence, as far as negligence by that boy is, my lord, it is not properly considered.
Proved. Not considered. You have not proved. Next, what about the compensation?
Compensation, the salary is taken, my lord, and it is not for personal expense. It is not deducted.
Let's see. What is the
para
age of
17, my lord. Age 16, my lord. 16. Para 17, where the future prospect, the income is calculated.
Calculated how much?
Lord, they have calculated 30,000 is taken and 18 is the multiplier. It comes to 5,40,000.
13,000.
Huh?
How much is taken as salary?
30,000 per annum. Multiplier is 18.
How much has to be taken? Yes,
Lord,
Mr. Sivan Nagoda.
But
In case of a 16-year-old.
Multiplier is correct, my lord.
Not multiplier. Income has to be taken how much?
Notional income has to be taken.
Which case?
Our number is judgment. There is a judgment.
That's what I'm saying.
Adolescent
So
person.
It has to be as per the chart.
Notional, yes.
It has to be as per the chart. So better we'll dismiss your appeal. Otherwise, agreed with the award passed in MBC number 670 of 2018 dated 16th February 2021, whereby the court had granted an amount of rupees 6,87,548. The claimant, the owner of the vehicle is before this court. It is a case of it is submitted that the court had failed to consider the fact that there is negligence on the part of the deceased, who is 16 years old, who has no driving license to drive the vehicle, and he has contributed to the accident. It is submitted that when it comes to the compensation, the court had not deducted the amount, and the compensation that is awarded by the tribunal is on the higher side. Next para. The notice is served in the respondent. No wakalat is filed on behalf of the respondents. Next para. Having heard the learned counsel of the petitioner, peruse the material on record. This court has perused the order award passed by the tribunal. As per the sketch exhibit P2, the vehicle that is at the time of the accident, the tractor, which is the offending vehicle, is on the extreme where it has to go. It has to be on the right side. It is on the extreme left side of the road, which clearly shows that there is negligence on the part of the driver of the opposite vehicle. Just because he is not having a driving license, that itself cannot be a ground for the court to fix a contributory negligence on the deceased. In that view of the matter, this court do not want to interfere with the findings of the court. Then coming to the compensation, in fact, in the right of the second law, the court has to take the notional income, but in this case, 30,000 per annum is taken. So even on that count also, this court is not going to interfere, and there is no appeal by the claimants. In that view of the matter, the appeal is dismissed. The amount in deposit shall be forthwith transferred to the trial court.
Case number 17, Putaswamy C. For
Appear
appellant.
for the appellant claimant, my lord.
Yes,
This
who
appeal
appears?
is for
Where is Mr. Vijay Kumar?
D. Vijay Kumar.
Counsel for the appellant is present. No representation on behalf of the respondent. Lists this matter on 9th of September. Yes.
Case number
actually
18.
there was a order, my lord.
Hmm.
In the absence of the respondent required, it will be passed in order.
Listen. Already such an order is passed.
Yes, my lord. Last week only, 6th.
On 16/8/2025, this court has passed an order directing the matter to be listed on 14/8/2025. And by that time, if the counsel for the respondent is ready or not, the matter will be heard today in the forenoon as well as in the afternoon. There is no representation on behalf of the respondent. List this matter part heard on 28th.
Much of.
Not 28th, list on 29th, 30th, the Saturday. Yes.
Much of.
Case number 18.
In this case, I appeal for it's a part heard matter.
Mm.
Your lordship has heard the matter.
Mm.
It's a private, the act policy. The pillion rider is not covered. They have taken time to submit.
Yes.
Sir.
My lords.
Are you ready?
But we have discussed with the senior. He has agreed with our contention.
Please, my lord, I agreed.
Their appeal has to go.
No, they want enhancement.
Enhancement of
That's what, which is 18 is their appeal.
Please.
Your appeal is on the liability itself.
They have also prepared appeal.
for the enhancement.
472.
First one,
482 of
482 is
20.
their appeal.
Yes.
Your appeal is on the liability itself because you are not liable.
I am not liable, but they are seeking enhancement.
Against whom? Against the owner of the vehicle. Yes. It's a case of death or injury.
Injury, my
Case
lords.
of injury.
Please come to that.
Date of accident 23/8/2018.
Huh?
23/8/2018.
Pain and suffering. Is the owner served? Or dispense with petition is filed?
No, madam.
My lords, notional income of the petitioner is also taken less.
Notice to R4, R2 to R4 is dispensed with. How can it be?
They have.
How can you seek dispensation of notice to the owner? No, owner is going to know if enhancement is ordered, owner has to pay either enhancement or otherwise.
None appeal.
Learned counsel for the appellant shall come up with appropriate application seeking for taking on notice on the respondent by way of substituted service of notice within by 16th of September.
Please.
The order where notice to the owner is dispensed with dated 7/2/2023. As far as which is the owner, R2 or
R2 to R4.
can't be so many people, owner of the.
He plays expert before MS.
Huh?
He placed ex parte before the MSc.
I think they
On that ground it is.
But I don't know on what basis they have filed the memo. But according to the cast title of the judgment, he placed ex parte before the court.
Maybe on that ground they sought for dispensation.
They can.
Look at it, look at the order, when it is, how it is dispensed with, on 7/2/2020, 2023, 7/2, in MFA number 482.
7/2/24 ಅಲ್ಲ? 23. In the beginning is.
Dated 7/2/2023. Is that? Look at the memo that must be there in the file.
That it is there in the.
In my appeal, my lord, he has served. Owner has served.
In other.
No, memo is not here. We'll record that because it's an ex parte order. So let's make the calculation. You said page number?
Page number 21.
What are the injuries?
Injuries are, my lord, traumatic amputation of right toe, abrasion right shoulder, abrasion.
He says,
Para 80.
what he says is, undersigned
number-
counsel appearing for the appellant respectively submit that there is no liability against the respondent number 2 to 4.
That is wrong.
Hence kindly dispense the notice to respondent number 2 to 4. The order dated,
Earlier, there is no liability, but he placed ex parte.
the order dated 7/2/20, or else you file another memo.
That's what. Let him file a memo. He
The order
placed ex
dated
parte.
7/2/2023 is recalled as it is stated that there is no liability against respondent number 2 to 4. In the light of the fact that it's an act policy and the insurance company is not liable, now it is a owner who is liable. Then counsel for the petition, for the claimant submits that they have remained ex parte and they will come up with an appropriate memo seeking dispensation. Is this matter on Saturday? By the time file the memo.
Please.
Yes, next.
23. 23rd ಅಲ್ಲ?
Yes,
Cell number.
19.
Cell number 19.
Yes, there is Mr. Lingraj. Yes.
Dismissed. Claim petition dismissed.
Dismissed.
Workman compensation because of the heart attack.
Huh.
You last time that judgment of Justice Nagaratna I brought.
Have you seen?
Seen that. But there should be, what they say, there should be a causal connection between this particular gentleman drives the vehicle and the vehicle is parked. Only in the morning he is dead. So my submission.
He has taken the vehicle or like in terms of his employment, he parked the vehicle and the accident has happened.
No, he went to sleep, and when the morning, when someone wanted to wake him up, then it appears that he was no more.
Let's see how it is narrated. If I remember what you said was, he went to some other place. That is still is under the, not that he's sleeping in his house.
Now, during the course of employment, but whether it arose out of the employment is to be decided.
That is what is decided in this. Have you seen the judgment? Have you seen it?
I seen it. It's
Which
given a
paragraph?
copy. Yes. They said there should be a causal connection.
The words arising out of and in the course of employment have been a subject matter of interpretation.
But what the commissioner concludes is that the distance which he drove was not that much stressful and he has taken.
That's what
That's
for him
the
to say.
reasoning.
In other words, an accident being an unforeseen event causing a misfortune of life, an omission which is a result of negligence or misconduct. Accident means an untoward mishap which is not expected or designed. Any injury which is not designed by the workman himself. Thus, the word accident would include all mishaps occurring by chance or caused unintentionally and events happening due to unforeseen circumstances under Section 3(1) of the Act.
One heart attack.
Even about the heart attack also they have discussed.
That they have discussed.
An extra unintended, unexpected occurrence. It must be in the popular and or not in technical sense. This paragraph number 17 in that Shakuntala Chandrakant.
That I have seen.
That is interpreted probably by the commissioner. It says
Yes.
the onus is upon the applicant to show that it was a work and the resulting strain which contributed to or aggravated the injury. I think this is interpreted.
Probably subpara 3, if the evidence brought on record established a greater probability.
The court said that there is a connection.
Now this court has also to hold that.
So then what about the compensation that has to be remanded?
No, remand. The date of accident is.
Anyhow, that is all we have to take. What are the other factors?
That is date of.
Medical expenses and all are there.
That is not forthcoming in the. That is not
forthcoming.
So in that case, what we say is that you are entitled, as far as the compensation is concerned, let the court decide.
Please.
Or else if there can be any negotiation on that also, we can conclude.
We don't know, but what evidence?
No, Your Lordship, as per the table.
No table. This is notification as per the Workmen Compensation Act.
Please.
That we have to see the factor and the age. That's all.
Factor is the age of the deceased is 48 years. Then 159.80 is the factor applicable. Then the income.
The age was LCR when PM report. The age as per the PM report has to. Because that is not discussed in the judgment.
I think better it's advantageous for you. I'll fix a time limit for that.
That's true. Please.
It's a simple thing to be decided. The present appeal is filed, agreed with the dismissal of ACN number 2 of 2017, dated 27/20/22, whereby the court has dismissed the claim petition. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs, along with interest at the rate of 12% per annum from the date of accident. It is a case of the claimant that the first respondent is the owner of the lorry. The deceased was driver of the said lorry at the time of the accident. On 17/1/2016, the deceased and the cleaner of the lorry, after loading the paddy sacks from KR Nagar, are going towards Kaladi Paddy Open Market. On the early morning at about 1:30 a.m. of 19/1/2016, they reached their destination, that is Ernakulam district, Kerala state. At about 5:30 a.m., the driver of the lorry parked the lorry in the premises of the rice mill for the purpose of unloading the paddy stock. At that time, the driver, Pasha, went for sleep in the cabin of the lorry. In the meantime, the cleaner was supervising the unloading of the sacks from the lorry. After completion of the unloading, at about 7 a.m., the cleaner called the driver to move the vehicle from parking place. When the cleaner tried to wake up the driver, there was no movement. And when he was taken to the hospital, he was declared as brought dead. The court had dismissed the claim petition. Which paragraph?
It is 21. Page 22.
The court observes that the deceased has taken more than 24 hours for covering the journey. The total duration which is required for covering the said distance is 404 or 450 kilometers. It may require around 9 hours. When the deceased driving 450 kilometers in more than 24 hours, the journey cannot be held as hectic driving and strainful driving. Hence, the court felt that the court has observed that
That it was not stress, it did not, that does not suggest any.
the court has observed that there is no causal connection relation to the death of the deceased with that of his employment as a truck driver, and hence he is not entitled for compensation. When counsel appearing for the appellant claimant had relied on the judgment of the apex court in case of the chairman, in case of the chairman Vaidyanath Sahakari Sakar Kharkhana Limited and another versus Shantabai and another, relying on this judgment, which is arising out of civil appeal number.
Civil appeal is not SLP number.
SLP number.
SLP number
29239
of 2019 submits that as the accident has happened during the course of his employment, he is entitled for compensation. When counsel appearing for the respondent insurance company submits that the court, the tribunal had rightly held that the work is not so stressful and it has not led to the death. As such, he is not entitled for any compensation. Next para, having heard the counsels on either side, peruse the material non-record. Before going into the facts of the case, it is appropriate to look at paragraph number
21.
14, 16, 14, 16, 14, 15, 16, 17, 18, and 19. In the light of the judgment the passed with the Honorable Apex Court, this court has no hesitation to conclude that the accident has happened in the course of employment and resulting course of employment, and the claimant is entitled for and he died in the course of employment. The claimants are entitled for compensation. It is a fact that he went to Kerala, and while the cleaner was overseeing the unloading, he was taking rest, and in the course, because he died, the finding of the court that it is not stressful is not for the court to come to such conclusion. Then coming to what is the compensation that he is entitled, there is no material before the court to arrive at such conclusion. In that view of the matter, this court inclined to remand the matter to the court to decide the entitlement of the claimants. Accordingly, this court is passing the following order. The order dated so and so is set aside, and it is held that the claimants are entitled for compensation. Number 2, what is the compensation that is payable? The court shall determine and pass appropriate orders within a period of 2 months from the date of receipt of the copy of the order. Without further notice, the party shall appear before the court on 2nd of September. 2nd of September. Yes, from that day, 2 months.
Only one submission. They have not filed the objections to the main petition itself before the tribunal.
Yes, next.
Any other?
Yes, next. Party, it will also go along order conditions, it will be there. Yes.
Cell number 20, adjourn 21. 21, or Shashidhara.
So you do one thing.
In this case, it's a
20.
connected mail, sir, Mr. Shashidhar told. 1115 of 23.
Post along with so and so. On
1115.
Write on a paper and
Of
please give
23.
her, the list along with so and so on 23rd, then 22nd, 22.
Cell number 22nd, 22, Mustaq Ahmed. 23.
23? No, September. Yes.
For enhancement, he has sought.
The list is matter, no representation, any of 452.
Yes.
List is matter on due to paucity of the time, the matter cannot be taken up. List is matter on 25th of September. Then
Number
23rd,
23.
23.
For the appeal, madam.
Okay,
This is
TK.
a climate appeal, madam. Seeking for enhancement of the commons.
Case of death or injury.
Injury case, madam. There's 7 years old child, madam.
On 15th of September.
Cell number
Yes.
24.
Same paucity of time on all these matters. 24.
Appearing for respondent lordship. This is claimant's appeal. I am the respondent case. That's the damage of vehicle.
24. This is a matter on 25th of September.
Cell number 25.
Much obliged.
I am for the appellant, madam. This is the claimant appeal.
Respondent.
It's a case of death or injury.
Injury, my lord.
Injury.
This is matter, same paucity of time. This is matter on 18th of September.
18.
Yes. Any signatures?
My submit. List 1, serial number 60, my lord. There is another matter pending between the same parties for the same relief that may be clubbed along with the list.
What had happened? 60. It's already signed and gone. Madam, 24 ಯಾವ ಡೇಟ್ ಕೊಟ್ರೆ?
Sir,
24.
one ನಿಮಿಷ. 24, 24, 18 September, one ನಿಮಿಷ. List 2 ನಲ್ಲಿ ತಾನೆ? List 2, 24, 18, 9, 20, issue 25, 9, 25, 9.